did, thank you.
Good morning, everyone. I'd like to hereby call to order the June 1st, can't believe it's June already, Escambia County Quasi-Judicial Planning Board meeting. We do have 4 members, so we do have a quorum. I don't know if we're expecting more, but we'll add them in as we go. At this time, I'd ask everyone to please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Staff members, do we have proof of publication of the meeting?
Yes, sir.
Okay. And does that publication meet all of the legal requirements?
Yes, sir.
Chair will entertain a motion to waive the reading of the legal.
So moved.
Motion,
Second.
second. All those in favor say aye. Aye. Opposed? Motion carries. You've been previously provided the rezoning meeting minutes from the previous meeting. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
So moved.
Motion, do we have a second?
Second.
All those in favor say aye. Aye. Opposed? Motion carries. The rezoning hearing package for June 1st, 2021 with the findings of facts have been provided to all of the board members. The chair will entertain a motion to accept that rezoning hearing package with the findings of facts and the legal advertisements into evidence.
So moved.
Motion, do we have a second?
Second.
Second, all those in favor say aye. Aye. Opposed? Motion carries. The rezoning hearing package with the findings of facts and the legal advertisement will be marked and included in the record for all of today's cases. At this time, we'll ask our court reporter to please swear in the members of the staff that are going to be testifying in the proceedings today.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Thank you, sir. Board members, you've been previously provided resumes and qualifications for these staff members and their ability to offer expert testimony in the area of land use and planning. Do any of you have any questions regarding their background or qualifications or their ability to offer expert testimony? All right, hearing none, the staff members will be considered experts in the area of land use and planning. At this hearing, the Planning Board is acting under its authority to hear and make make recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings, however, they are less formal. All testimony will be given under oath, and anyone testifying before the Planning Board will be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the information in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to address the Planning Board must complete a speaker request form. They're located at the back of the chambers. You will not be allowed to speak unless we have received a speaker request form. Please note that only those individuals who are present and give testimony on the record at this hearing before the Planning Board will be allowed to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented at the BCC meeting. Therefore, all testimony and evidence must be presented today. The Planning Board will provide a recommendation for each rezoning request to the Board of County Commissioners. They will review the testimony, documents, and exhibits and consider the closing arguments. They will make a final decision. All decisions by the BCC are final. Anyone who wishes to seek a judicial review of that decision must do so in a court of competent jurisdiction within 30 days of the date that the BCC either approves or rejects the recommended order from the Planning Board. All written or oral communications outside of the hearing with members of the Planning Board with any matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided by BCC Resolution 96-13. As each case is heard, the chair will ask any board members who have had any ex parte communication, please identify themselves and describe the communication. The rezoning criteria, as required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following 5 approval conditions. Approval conditions: the applicant has the burden of presenting competent substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary. Those use and conditions is not necessarily the same as required for the mailed notification. A logical and orderly pattern shall require demonstration of the following conditions. A, consistent with the comprehensive plan. The proposed rezoning is consistent with the future land use category as prescribed in LDC Chapter 3 and with all other applicable goals, objectives, and policies of that comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment, it must be transmitted to the state agency for review. The proposed zoning is consistent with the proposed FLU and conditional to its adoption. Consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed in the proposed district in the chapter. Compatibility with surroundings. All of the permitted uses of the proposed zoning, not just those that are anticipated with the rezoning applicant, are compatible, as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with the potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there's no additional burden to demonstrate compatibility with specific residents or activities that are already covered under fair housing laws. Appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character between the adjoining districts, or the differences within those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balance of interest between the isolated district and the adjoining lands. Appropriate with changed or changing conditions. If the land uses or development conditions within an area surrounding the property of the rezoning have changed, the changes are to such a degree and character that it is in the public's best interest to allow new uses, densities, or intensities in the area throughout the rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we'll allow the staff to briefly present location and zoning maps as well as photography of the property. Next, we'll hear from the applicant and any witnesses they may wish to call. Then we will hear from the staff and any witnesses they will call. Finally, we will hear from members of the public who have filed a speaker request form. We have 2 cases today, and we will go ahead and get started right on them because I think we might have a little bit of a long morning here. So the first rezoning application for consideration is case Z 2021-03. The applicant is Buddy Page, who's acting as the agent for B&E Holdings, LLC, the owner. 5900 block of 9 Mile Road, 1.21 plus minus acres, from low-density residential 4 dwelling units an acre to commercial district 25 dwelling units per acre. This time I'll ask members of the board, has there been any ex parte communication between you, the applicant, agents, attorneys, witnesses, fellow planning board members, or anyone from the general public prior to this hearing? Also ask if you have visited the subject site, and please also disclose if you're a relative or business associate of any of the parties involved. Good morning, Steve.
Morning, no to all.
Thank you. Patty?
Good morning, no to all.
No to all.
No to all.
Chairman, no to all.
No to all.
All right, thank you. Staff, was notice of the hearings sent to all interested parties?
Yes, sir.
Okay. And was it also properly posted on the subject property?
Yes, sir.
Okay. Mr. Page, any objections to the maps and photography being shown? Okay. Staff members, who will be presenting on this one?
I will.
Good morning.
Good morning.
If you would state your name and position for the record, please.
Absolutely. Andrew Holmer, Escambia County Development Services Department. This is rezoning case Z 2021-03. This is a location map. You can see it as near the intersection of Beulah Road and 9 Mile Road, just to the south. This is the 500-foot radius showing the zoning on site as a split zone, low-density residential and heavy commercial light industrial. Existing land uses in the area. The future land use for the site is mixed-use suburban. This is an aerial map of the site. Conditions have changed somewhat since that photo was taken. There's a shopping, a Publix right across the street now. This is the public hearing sign posted on site. This is looking north along Beulah Road. This is looking south along Beulah. And this is looking directly across to Beulah to the Publix. Would you like me to go ahead and go through the findings at this time, or?
I had to step out for a call. Could you please swear me in, please? Just in case if I need to speak.
All right, thank you. Dave, if you would swear in Mr. Jones, please.
Do you solemnly affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth?
I do affirm.
Andrew, let me bring Mr. Page up and let's go through his qualifications for the case. And so, good morning, Mr. Page. If you'll come forward, please, sir. Sir, if you'll please be sworn in and then state your name and address for the record.
Do you solemnly swear the testimony about to give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good morning, Mr. Page. Have you received a
Morning.
copy of the rezoning hearing package and the findings of fact?
Yes, I have.
Okay. Do you understand that you have the burden of providing substantial competent evidence that this proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with any portion of the Land Development Code?
I do.
Thank you, sir. You want to?
Thank you, Mr. Chairman. Buddy Page, 5337 Hamilton Lane in Pace, Florida. Mr. Chairman, I would, in the interest of time, just make one inquiry. Do you have any speakers for this particular item?
We do have Mr. Gary Watson, but I'm not sure if he's a witness for your.
He's one of the clients.
Okay, all right. So that's the only speaker that signed up at this time.
Mr. Chairman, in view of that, I would offer to adopt the staff findings as our own.
Okay. All right. Board members, you know in cases where the applicant is in agreement with the staff's findings, we sometimes will do an expedited move on the case just to avoid delaying what we think is the inevitable, but he's accepted the staff's findings. So are there any questions for Mr. Page? That's $5 for the donut fund.
Mr. Chairman,
Yes, sir.
I think Mr. Watson may have one brief comment on
Okay.
this,
All right.
particular one.
Good morning, sir. If you'll
Good
please
morning,
be
Mr.
sworn
Chairman.
in.
Yes,
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Sir, if you'll please state your name and address for the record.
Gary Watson, 1308 North Barcelona Street, Pensacola, 32501. I just want to thank you guys for doing what you're doing. Takes a lot of your time, I know that. Want to confirm and agree with the staff's findings. Thank you.
All right. Thank you, sir. All right. Mr. Page, did you have any other?
I have nothing further.
Okay. Is there anyone else that wishes to speak on this matter? All right, we don't have any speakers. Drew, if you want to just give an abbreviated version.
Yes, sir. So in doing our review, staff finds that this is consistent with the required criteria, fits in the area, and we're all well aware of how growth is coming to that location.
Okay. And in your findings, it's consistent with all the approval conditions?
That is correct.
Okay.
Yes, sir.
Unless there's questions, the chair will entertain a motion on this rezoning request.
Move to approve.
Motion to approve, do we have a second?
Second.
Second. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carries unanimously, all right? Stay up there, buddy, because we're gonna come right back to you with number 2. All right, board members, we're going to move on to our second case, which is case Z 2021-04. Mr. Page is also the agent for Russell Collins, PA, trustee of the 310 North Navy Boulevard Land Trust from April 7, 2020, who is the owner. This is 310 North Navy Boulevard, 0.61 acres, from medium-density residential to commercial district. On this case, members of the board, has there been any ex parte communication between you, the applicants, agents, attorneys, witnesses, planning board members, or general public prior to the hearing? Also disclose if you have visited the subject property, and disclose if you are a relative or business associate to any of the parties. Steve?
No to all.
Thank you.
No to all.
No to all. No to all.
Chairman, no to all?
No to all.
Thank you. Staff, on this case, was notice of hearing sent to all interested parties?
Yes, sir.
Okay, thank you. And was that also properly posted on the subject properly?
Yes, sir.
Okay, thank you. Mr. Page, you okay with the maps and photography on this one? All right. Good morning. Allison, are you going to be? Okay.
Good morning. Morning. Allison Lindsay, Development Services. Okay, this is the Z 2021-04, 310 Navy Boulevard. Here's the location map showing the location on Navy Boulevard and Druid Drive. This is the 500-foot zoning map showing the current zoning of the parcel's MDR. This is the existing land use showing the existing uses around the parcel. And this is the mixed-use urban future land use designation. And it's in the AIPD 2 Navy area. And it's also in the Warrenton overlay. And this is the aerial photo of the site. And this is the sign posted on site on Navy. And this is the parcel that's fronting on Navy Boulevard. This is looking onto the subject property from across Navy Boulevard. This is looking west across Navy Boulevard from the subject property. And this is looking north along Navy Boulevard from the property. This is looking south. And this is the rezoning side that we posted on Druid Drive. This is at the rear of the first parcel from Druid. And this is the middle parcel, the second parcel on Druid Drive. And then this is looking onto the easterly parcel along Druid, the farther parcel. And this is looking onto the parcel from adjacent to the school.
Okay.
And this is looking southeast from the intersection of Druid and Navy Boulevard. This is looking east along Druid. This is looking northeast across Druid from the property. Looking west along Druid toward Navy Boulevard from the middle or the farthest parcel. And that's the maps and photography.
Okay. Board members, any questions on the maps or photography? All right, Mr. Page, if you'll come back forward again, sir. Please recognize that you are still under oath, and on this case, have you received a copy of the hearing package and the findings of facts? And on this case, do you understand that you have the burden of providing substantial competent evidence that this proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with the land development code?
I do.
Thank you, sir. Go ahead.
Mr. Chairman, on this one too, I would ask first if you received any speakers requests.
We have Mr. Watson again as the only speaker signed up at this time.
Mr. Chairman, in view of that, I would offer to adopt the staff findings as our own.
Okay. Board members, any questions of Mr. Page? All right. Allison, we can do expedited. I did have one question concerning that this is adjacent to the school and the issue of alcohol sales. We have commercial, but we're not giving any designation for alcohol. Is that just because it's limited by the distance?
Yes, sir, and at this point, we don't know, as far as commercial, what's going to be
Okay.
in the further development at this point.
Okay.
But this case does,
And I want to add to that, even if there is the potential for that, the land development code does have some criteria, and it's a no, and Ms. Hightower was raising her hand, so we will have to review that at the time if it is alcohol being proposed, or whatever the provisions are, whatever the rule of law is, that's what they will have to abide by. I just want to state that for the record.
Okay. Thank you. Allison?
okay. So yes, this case is, it does meet the requirements. It is in the AIPD 2 overlay, which is not as restrictive as the AIPD 1. So it really wouldn't have much of an effect on their development, being the commercial aspect. It is mixed use, urban. You can have, and this is in the Warrington overlay, so the CRA is here to comment on that. They did provide a letter. They were fine with the two parcels, the one on Navy and the middle parcel, but as the photos show, there was a existing single-family house, very well dilapidated and not in use at this time, but they felt that, you know, they weren't really in agreement with that one changing the use. Most of the surroundings on Druid Avenue are all residential. The ones on Navy, as you know, Navy Boulevard, it's an arterial, so it does have commercial on that side. Across Navy Boulevard, there is residential within that 500-foot radius. But anything that comes up for development would have to go through location criteria, distance for alcohol, and any other of those issues that may come up at development.
Okay, Allison, in the staff's findings, did all of the parcels that are being combined, did they all meet the criteria, the approval conditions?
Yes. Now, at this time, we don't know if they're actually combining the parcels or if they're going to just use them each individual as 3 parcels. So here again, not that would weigh too much. Go ahead, Mr. Page.
Mr. Page?
Mr. Chairman, it'll be developed as a single parcel. And also, I just spoke with Mr. Watson. The buyer would agree to an addition or an amendment to the application stating that there'll be no alcohol consumption on the premises.
Okay.
And that would be the, what is going to HCLA NA? So therefore, he's making a motion basically to amend it, which we can, at this process, the law does allow you to go down, you just can't go up. So heavy commercial, light industrial, NA, and the NA represents there would not be no alcohol.
Right.
Okay, and in that case,
So I thought it was okay, so are they going to?
Do they want to stay commercial?
So for the record, I'm sorry for that, I was given that information. He's indicating that there would not be no alcohol. Commercial does allow alcohol. We don't have no conditional use process or conditional use zoning. But for the record, Ms. Kidd, we don't have no conditional use zoning. It indicating that it would not be no alcohol. So I guess that would be confirmation, affirmation that no alcohol will be, for the record. Okay. Just want to be clear with the record, indicating that there will be no alcohol based upon what they are indicating.
all right, and that's picked up in the DRC process as
Yes,
well then?
yes.
Okay. All right, Steve, since this is in an airfield influence planning district, any concerns on behalf of the Navy?
There are no concerns. AIPD 2 is much more lenient than 1. This is on the very edge of it. So, I mean, of course, anytime you're near the airfield, there's noise, but we don't even overfly that area, so no concerns from the Navy.
All right, thank you, sir. Ms. Hightower, it's near a school. Any concerns from the school board?
Not at this time because of the process. We know we'll be able to be heard. when you're talking about you're not changing it here, we know that on the planning board, we're not able to determine what will actually go on there. We're just saying whether this is okay or not. So I'm confident that with the other criteria as we move forward, that'll be taken care of.
Thank you, ma'am. Staff, anything else? Okay, Mr. Page?
One final comment.
Yes, Mr. Watson? Sir, you've been previously sworn in. You still are under oath, and for this case, just state your name and address.
Gary Watson, 1308 North Barcelona Street, 32501. I just want to agree with all of staff's findings.
Okay, thank you, sir. All right, board members, any questions for staff or the applicant? Chair will entertain a motion.
Move to approve.
Motion, do we have a second?
Second.
Second. Any further discussion? All those in favor say aye. Aye.
Aye.
Opposed? Motion carries unanimously.
Thank you.
All right, good luck. Okay, do we have anything else for the quasi-judicial hearing? All right, hearing none, we are hereby adjourned in the quasi-judicial. And we will go directly into calling our regular planning board meeting into order. We still do have 4 members. He may have stepped out of the room for just a moment, but we'll make sure he's back before we start any cases. Staff members, on this meeting, do we have proof of publication?
Yes, sir.
Okay, and does that publication meet all of the legal requirements?
Yes, sir.
Chair will entertain a motion to waive the reading of the legal.
Second.
Motion and a second. All those in favor, say aye. Aye.
Aye.
Opposed? Motion carries. Previous meeting minutes have been provided. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
So moved.
Motion. We have second?
Second.
Second. All those in favor, say aye.
Aye.
Opposed? All right, motion carries. The hearing package for June 1st, 2021 has previously been provided to the board members. Chair will entertain a motion to accept that hearing package and the legal advertisement into evidence. Do we have a motion?
So moved.
Motion, do we have a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Okay. We're going to come back to the follow-up reports for the end of the meeting. But at this time, we'll go ahead and go directly into public hearing. This is case OSP 2021-01. The applicant is Mr. Frank Westmark, who is the agent for David A. Zucales. I hope I pronounced that right. And Maggie Louise, I'm not even going to try it again, care of Kathy Zucales Hopkins, who is the owner, 810 Neal Road, 32.4 plus minus acres, from conservation neighborhood to mixed-use suburban. Okay.
Mr. Chairman,
Yes.
before we get into that, could you guys please vote again on the approval of minutes and the acceptance of the meeting packet? We have the motion in the second, but because we didn't have the quorum, could you please vote again?
Okay. Thank you for catching that. The chair has entertained a motion to accept the hearing package and the legal advertisement into evidence. It's been properly second. Mr. Sammons, you were out of the room when we took the vote, so all those in favor say aye.
Aye.
Opposed? All right, motion carries by all 4, carrying the quorum.
And then the approval of the minutes as well.
Okay. The previous meeting minutes have been provided with a motion and a second. There are no additions, deletions, or corrections, and we'll take the vote again. All those in favor say aye.
Aye.
Opposed? All right, motion carries. Does that clear us up, Kia?
Yes, thank you.
All right, thanks for keeping us on track. Okay, I've opened the case for OSP 2021-01. Who will be presenting on behalf of the staff?
Chairman of the Board, John Fisher, Senior Planner.
Good morning, John.
Morning, y'all. I do want to make a quick note. The pictures that were for this case were not submitted. We need a amendment to accept those pictures as indicated. The site pictures were not,
Okay, who took the pictures?
actually, I did, John.
You
Fisher.
did? Okay, so you're submitting the pictures as an addendum to the findings of facts then, is that correct?
Yes.
Okay. And you personally took each of the pictures and you'll walk us through a description of them?
Yeah.
Okay.
Standard.
Chair will entertain a motion to accept the pictures taken by the staff member as an addendum to the package.
So moved.
Motion, do we have a second?
Second.
Second. All those in favor say aye.
Aye.
Opposed? Motion carries. All right, go ahead, John.
Okay. Again, this is OSP 2021-01. As you see there, this is a location map off of Neal Road and at the top of Pine Top Lane. This is the zoning map, currently zoned LDR. You see a 500-foot radius and a 1,000-foot radius to give you some dimensions there. This is the flood zone, currently zone X. This is the old previous future land use AA15 Cottage Hill Quintet. This is the existing future land use DSAP map, conservation neighborhood. As you see to the east, that was a previous case, Ms. Robertson's case that we had talked about several years ago that was approved. This is OSP 21, proposed future land use, mixed-use suburban map. This is what they're proposing. This is remnant and pending case maps showing the area. And this is the aerial map. Here you see the public hearing sign posted on site. This is looking west along Neal Road. This is looking north at the subject property at the end of Pine Top Road. This is looking east along Neal Road and looking southeast from the subject property. Looking south from the subject property. And that's all the photos and maps at this time.
Okay, could you go back to the one that I think it said remnant cases? I just want to make sure everyone understood what that is. Yeah, go back one, there you go. And what is the thick black line outlining?
So
What
that
indicating?
that is one area of the Jack's Branch area. So each, the sector plan has Muskogee and Jack's Branch, and this is one of the areas. JB 51 is where we have done, part of the packet was they did calculations for low density, medium density, and high density. This is where they did their data analysis. The next one over would be like JB 50 to the west and to the south. Each area has its own calculations for traffic, concurrency, and so on to try to keep the density in those areas is how they broke down the data analysis.
Okay. All right, thank you. Board members, any additional questions while we have this one up? We can come back to it if we need to. Okay. We're going to hear from the applicant, and then we'll come back to you, John, and you can give the staff analysis of it. Good morning, Mr. Westmark. If you'll come forward, sir, please. State your name and address for the record.
Yeah, turn that on there. Hold on.
One minute, Mr. Westbrook, let me cut you off. You got it?
Is it not up? Yeah, it's operating.
Yes, sir.
The correct name is Zokeles.
Zokeles, okay.
Took me a while.
Yeah.
Elizabeth and I are here as agents for the Zokeles estate to request your favorable recommendation for their opt-out of the sector plan. We also remain agents for the Cottage Hill Baptist Church, whose opt-out you approved in October of last year. The church and the Zokeles estate share a common interest that I'll get to shortly. Before I do, I have 2 or 3 things to say about John Fisher's data and analysis. He hasn't said it yet, but I assume that it's that it's the same that's in the package. Keep me from coming back up here again. One, Elizabeth and I have reviewed it thoroughly and determined that it's professionally done, and we commend him for it. We are confident that it will stand up to any challenge in a DOA hearing. if there's any doubt about that, after the last hearing in 2020, the staff has a mountain of additional data and analysis that can be admitted into evidence up to and during trial, plus supporting judicial rulings. You don't get off that easy, John. Secondly, there are a couple of things in the analysis that need correcting. Right before we go there, I want to be clear that Mr. Fisher is not to be blamed for any mistakes. The same mistakes have been made in previous opt-outs and have sort of become staff boilerplate. On page 5 of the staff analysis under recreation and open space, you have that in your package.
Let's bring it up on screen, please.
I'm sorry?
We're going to bring it up on the screen so we can all see where you're at, sir.
Good, good, very good. Page 5 of the staff analysis, are we there?
Yes, sir.
Okay. Recreation and open space. This is a compliance issue, so it's important to get it right. This analysis says, Section 3.03, Conservation Neighborhood Guidelines, Open Space. The intent is to be low-density clustered communities with an interconnected open space that will serve to protect and preserve areas of significant natural resources and wildlife habitat while offering passive recreational opportunities to residents. The question here is that the word passive is no longer part of the regulation in Section 3.03. You have to go to the current online version of the county's regulations to find that. Apparently, the word passive was in the original documents up to the adoption of the DSAPs themselves in September of 2011. And this change was made evidently before the DSAPs were finally adopted. The current regulation in Section 3.03, page 57 of the DSAP document, paragraph 3 says, I quote, open space shall consist of one or more of the following. One or more of the following. Improved common open space dash open space set aside for recreational purposes. These areas may contain accessory buildings and improvements necessary and appropriate for recreation and/or public use. That broad language would cover clubhouses, swimming pools, tennis and basketball courts, fenced, golf courses, athletic fields, whatever a homeowners association or a builder might put out there for recreation. The judge in the recent DOA hearing ruled 3 weeks ago that on this, and the same language is essentially used. Paragraph 4 on the same, you don't have, I don't think you have this, but the paragraph 4 in the reg says, up to 1/2 of the required open space may include stormwater facilities, provided such facilities are designed as a community amenity. In other words, 100% of the required open space can be used for improved recreation, or half for improved recreation and half for stormwater facilities. The point is, the required open space is unlikely to be used solely for conservation or remain pristine as some people envision. With so much misinformation flying around these days, it's important for people to know that what these regulations actually say and mean. It's also important to note that this staff analysis will become evidence in a DOA trial if this amendment is challenged, and what's said in the staff analysis is generally presumed to be correct. This may discussion may become academic because, in my opinion, there's not likely to be any more subdivisions in the conservation neighborhood of the sector plan. You can't develop it because of the regulations. They only had one, and it was a kind of an anomaly. I won't take up your time with that.
Mr. Westmark, just while you have a pause there, I'd just like to recognize that Mr. Reed Rushing has joined the meeting, so we've added to our quorum. I just wanted to get that on the record that he's
Good.
part of the meeting now.
Good.
So
Thank you very
go ahead,
much.
sir.
Good morning, Mr. Reed. As sort of a sidelight, you can't predict what's liable to turn up as evidence in one of these state hearings. A Tampa-based witness for the petitioners in the recent hearing was accepted as an expert on coastal birds. She testified that the opt-outs should not be approved because that would increase the population of domestic house cats and feral cats that would eat up all the birds. The fact is, the coyotes eat the feral cats, and most of the house cats wisely stay home. Deer and turkey hunters keep the coyotes under control, and the birds don't have much to worry about except the hawks. Final thing is that on page 13 of the staff analysis, numbered paragraph 9, if you'll go there, please. I've complained about this one in the past. Hopefully we can get squared away here today. Concerning the whether or not the property owner gained or lost development rights as a result of the sector plan. We there? Okay. Says says based on the available data, the residential density for the parcel was in fact increased by the adoption of the sector plan and the assignment of the conservation neighborhood land use under the DSAP, which provides a maximum of 3 dwelling units per acre. Well, that's correct. The parcel had VR2 zoning, which calls for 1 dwelling unit per 0.75 acres, or roughly, not roughly, but precisely 4 dwelling units for 3 acres. On a 30-acre tract, we'd be looking at 40 allowed dwelling units per 30 acres. The sector plan with 3 dwelling units per acre would allow for 90. However, when you apply the 50% taking rule that takes half the man's property away from him, then you have to bring the future land use requirement down commensurately by 50%, so you get to 45 dwelling units on that same 30 acres. Not a lot of difference between 40 dwelling units versus 45 dwelling units. And the 45 dwelling units, you have to get those dwelling units. They're not there and not assured. It depends on the topography of the land. So it's basically a wash. And the claim that the sector plan actually increased the development rights on the property is false. Maybe a wash. However, the 2030 comp plan that assigned the subject property an MSU FLU became effective in March 2011, 6 months before the DSAPs were approved. We have 2018 data taken from the county's website and our own research that shows the property's future land use prior to the adoption of the DSAP was MUS, allowing up to 25 dwelling units per acre through rezoning. There's such fog surrounding what actually took place during that 2010-2011 time frame that we frankly don't stand on either our data or the staff data. The one thing is clear as a bell. If the sector plan had never been approved, the Zocalis property would have been zoned LDR with an MUS flu years ago. The fact is indisputable. In fairness, this opt-out amendment would merely restore what the Zalkalis family was entitled to that the sector plan took away. The truth of that statement is evidenced by the lack of significant development. I got ahead of myself. It is also clear that the detailed specific area plans are not plans at all, and that's important too. They are overlays of regulations that effectively smother development. The truth of that statement is evidenced by the lack of significant development anywhere in the sector plan during the greatest building boom we have seen in Escambia County in my lifetime. And I have lived here a long time. Here we are continuing to waste time kicking a dead horse. Neither you fellows nor the commissioners are happy with this situation. And neither are the landowners in the sector plan, large and small. It's past time to rescind this thing that should never have been approved. You could help move that forward with an appropriate resolution to the BCC, which we talked about 6 months ago. We urge you to do so on behalf of the small property owners like the Zalkalis family. In 1972, Dr. Zalkalis and his wife Maggie bought a 50-acre tract of residential property on Highway 29 and Neal Road and built a nice home there. Prior to their deaths, the Zalkalis sold 10 acres in 2006 to the Cottage Hill Baptist Church for $175,000. They sold 8.7 acres of commercial property on Highway 29 for $451,000 to Wilson Robertson in 2008. Wilson applied in 2016 when he discovered the DSAP Conservation Neighborhood Overlay had cut the value of his property to practically nothing. Both of those Zalkalis sales to the church and Robertson were based on fair market value at the time. Now, the Zalkalis heirs want to sell 30 or so acres of the remaining property to Breland Homes for fair market value, but they can't do it because of the restrictive DSAP conservation neighborhood regulations. Mainly the 50% rule that you're familiar with and the mandatory clustering and open space design rule. The Baptist Church is in the same fix. Breland Homes has a conditional contract with both the church and the Zalkalis estate to buy and combine the two properties into one development. You have a preliminary drawing on the project on page 12 of the working case file in your package immediately following my cover letter, and you may be able to get it up on screen. Is that possible? Can you get that drawing up on screen, John? There you go. That's it. You see there to the east adjoins Wilson Robertson's property that fronts on Highway 29. And to the west, it adjoins, I believe, the Knollwood subdivision. And with an entrance down there, a very nice wide entrance down on the Neal Road. Both these transactions are conditioned on the church and the Zalkalis property getting out of the sector plan. The reason is simple economics. No development company is going to pay full price for expensive land and give up half of it for no money. Conversely, the property owners are not going to give up half of their valuable property without full and fair compensation as provided by law. This proposed Breland subdivision is really a nice project with a density of slightly over 2 homes per acre, lots of open space. Standard amenities for all Breland developments are comparable to sector plan subdivision requirements. They include underground utilities, 26-foot wide streets, curbs and gutters, street lights, sidewalks, landscaping with trees, and other attractive features. If all this works out, the residents of Knollwood subdivision and other adjoining and nearby properties can take some comfort in knowing this part of their neighborhood will remain in low-density residential in perpetuity. In our view, this is a win-win proposition for all the parties. The church and the Zarcales estate receive full, fair market value for their land. Breland gets a nice property to develop and hopefully makes a profit. The county gets needed additional housing and a $25 million plus infusion into the local economy. This is the kind of really good thing that we should all be working together on. We can take some pride in helping to make it happen. I'll rest my case on that note and ask for your favorable vote for the Zarcales opt-out. On a personal note, this is probably my last time to address this board, and I just want to tell you that it's been a pleasure. It'd be nice to get a unanimous vote on my last one. And Mr. Chairman, I'd appreciate the opportunity to respond to any adverse comments at the end. Thank you so much.
Thank you, Mr. Westmark.
Any questions?
Mr. Chair, assuming if there is, I know we have discussion, we've got a ways to go, but based upon the findings that the Chapter 3 was either dated or incorrect, does that need to be part and parcel to updating that, John?
So Mr. Westmark is correct. The word passive was deleted from the new adopted sector plan. The overall intention of the analysis was a synopsis of A, B, C, and D. He just went over and broke down each one as he went through his section.
Thank you. And Mr. Westmark, appreciate your thoroughness.
Thank you.
Thank you, sir. Mrs. Westmark, did you wish to also address this?
Only just as a general, whenever, if you have other speakers, just.
Okay,
in that
all right.
way, so I can do it now or later, whatever works for you guys.
Okay. Let's go ahead and hear from the staff analysis, and then we'll go into our people that have signed up to speak on the matter.
All right. Thank you, Chair and Board. John Fisher, Senior Planner. Again, this is OSP 2021-01 at 810 Neal Road. This property owner is requesting a parcel be removed from the Escambia County Midwest Sector Plan in the Jacks Branch Detail Specific Area Plan, DSAP. Within the DSAP, the existing land use and parcels is conservation neighborhood with a maximum residential density of 3 dwellings per acre. The applicant's request is to assign a future land use of mixed-use suburban to the parcel. The applicant stated that the sale of this property for the residential subdivision by Mullins LLC is contingent on the approval of this opt-out. According to the Escambia County Properties Appraisers, this is around 32.4 plus or minus acres. The standard map criteria, availability of facilities and services. Under the analysis, within the DSAP document, analysis was conducted and conceptual portable water distribution system was developed Portable water in the area of the DSAP is supplied by Cottage Hill Water Works. Portable water will be analyzed both in the 5-year build-out of the development program. The conceptual water distribution system was developed based upon this analysis and is in a figure 4.03A of the DSAP document. Wastewater is supplied to the region by Emerald Coast Utilities, ECOA, with the LOS standards within Escambia County being 210 gallons per residential connection per day. The subject property lies in the College Water Hill Works. ECOA did not respond with a letter saying water distribution or sanitary sewer collection is available, but may require various extensions, additions, upgrades, and/or modifications to the existing ECOA water and/or sewer infrastructure that developer may be required to pay for installed as part of the project if ECOA is used. There was no additional information from Cottage Hill Waterworks Incorporated other than the project lies in their district. Solid Waste Services, LOS is 6 pounds per day. Funding for the expansion improvements to the portable distribution and water treatment systems within the service area are technically generated by the respective utility authority. At the time of the submittal, the applicant provided a letter from ECOA regarding the availability of portable water and wastewater. The applicant's analysis documented that the residential subdivision development is contingent on the approval of the opt-out. Under stormwater management analysis, based on the DSAP's original analysis for stormwater in the area sector plan, stormwater systems should be developed as a regional systems and encompass multiple areas of development. Attempts should be made to design stormwater treatment continuation systems, supporting conveyance pipes, wells as complete systems. All documents are required to meet and exceed standards established by Northwest Florida Water Management District. The applicant stated that the sale of the property of residential subdivision by Mullins LLC is contingent on this approval. Compliance with the stormwater management provisions will be reviewed and confirmed prior to any site development plan approval. Under Section E, traffic, the analysis, and access management. Section 4.02, the public facilities plan. Under the Midwest sector plan, a transportation analysis was conducted on different roadway segments, evaluating the existing facilities and travel characteristics as well as potential impacts of the road needs for a 5-year interim period in the build-out of the plan. There are various transportation improvements and expansions plans near the DSAP, including capacity expansions of US 29, I-10, and 9 Mile Road. The county's Traffic Transportation Department has provided comments. At this time of submittal, the applicant stated that the approval of this opt-out is contingent on, again, the sale of the property and residential subdivision. Any proposed development should provide a trip generation demand as well as a maximum impact if the property were developed to the maximum residential density. The project shall submit a subject for review and approval for the site plan review process. Section F, recreational open space. As Mr. Westmark has stated, the conservation neighborhoods are intended for provide more efficient environmental protection development plan as per Midwest Sector Plan Section 3.03, conservation neighborhood. The intent is to be low-density cluster communities within the interconnected open space that will serve and preserve areas, significant natural resources, and wildlife habitat while offering recreational opportunities to residents. Parks and recreational facilities within the neighborhood will promote physical activity as well as add the overall value of the neighborhood. Under Section G, public schools facilities, as per the sector plan, analysis for the schools was completed for the proposed SMA and DSAP impacts for both the 5-year and build-out conditions. Based on the public records of Escambia County, the schools that are assigned in service area are Jim Allen, Ransom, and Tate. The school district is part of the site plan review process, having the ability to comment on all proposed projects in Escambia County. The applicant stated that the sale is contingent on the approval of the opt-out. Under impacts and natural resources, wellheads, based on the geographic information system layer, the subject parcel is not located in a wellhead protection area. Under historical significant sites analysis, the applicant provided documentation stating that there are no previously recorded historical resources within the parcel. The Escambia County Comprehensive Plan has a section for historical preservations at any time during the development. If artifacts are discovered, they are to cease construction under policy OBJ FLU 1.2 historical resources. Under natural environment, as stated, the sector plan, the DSAP contains significant wetland systems that are as a regional significant natural resources by the Emerald Coast Planning Council, and that the final design was to avoid and minimize wetlands impacts in the greatest extent possible. Any construction or development will have to go through the site plan review process for further evaluation. Under changes of an existing DSAP, evaluations and analysis in recognition of the benefits of the long-range planning for a specific area, Escambia County adopted the sector plan, which is intended to promote long-term planning and development and conservation. The primary components of the sector plan are the two DSAPs, the Muskogee and the Jacks Branch, that capture the consensus of the long-term vision for this area. Both DSAPs were assigned development types and associated densities based on the appropriation shared of all the sector plans. The subject parcel is in the southeast area of the Jacks Branch DSAP with access with the Neal Road to Highway 29. Analysis of the DSAP land plan designated the parcel as a conservation neighborhood. If approved, the request removal of the parcel would not create a fragmented DSAP or a remnant as the previously approved to the east was a opt-out, which has already been removed, so this would create no remnant. The total development acreage in the entire sector plan is 8,611 acres. Based on the staff's calculation, utilizing the data of the DSAP document, section 2.02, the applicant's parcel totaling 32.4 represents 0.38% of the existing developable acreage of the sector plan. Under section 2.02, development program calculations table, page 34, the DSAP, the total residential development acreage of the Jack Branch DSAP under the conservation neighborhood land uses is 2,565.6 acres. Removal of the applicant's 32.4 acres will result in a 1.26% decrease in development acres. Under the figure A, JB1, there's a low density, medium density, and high end density respectively, showing 23 dwelling units and 238 dwelling units and 716 as a high density. Derived from the analysis of the baseline, staff identified the following trends. JB61, the applicant's parcel are represented 0.38% of the total developable area. Removal of the applicant's 32.4 acres from the total development acreage for the section JB51 will result in a reduction of 97.2 total dwelling units under the high density allocation. Almost there. The original sector plan profile identified approximately 15,000 acres of the land, availability of infrastructure and public services, and protection of the natural resources. The calculations used to compute the maximum development scenarios for the plan were specific and resulted in a balanced job to housing ratio. Changes to the variation of any of the original data used to the plan could hinder the balance and viability of the attending the sector plan's goals and objectives. Assuming a maximum theoretical build-out under the mixture of uses, the DSAP area would produce approximately 27,145 jobs. When an analysis using a maximum residential build-out of 23,000 dwelling units. The result is the jobs to employee residents ratio of 1.19. It should be noted, although there is no single perfect ratio of the area is generally considered to be balanced. If the job to house ratio of roughly 0.08 to 1.2. If the proposed amendment is approved, the resulting job to house ratio will be 1.21. Under the transportation infrastructure, there was an attached letter submitted from DTO, as you can find in the attachments. Under Part 7, the consistency of the request of future land use destinations with the underlying zoning. Should the opt-out be approved and the future land use mixed-use suburban category assigned, the most intense uses will be dedicated by the LDR zoning category, which allows for residential development of 4 dwelling units per acre. The requested MUS future land use category will be consistent with the underlying zoning uses, densities, and intensities allowed by LDR. Under the analysis to consider whether the applicant lost development rights was effectively downzoned as part of the sector plan adoption, the single-family residential property of 32.4 plus or minus acres had a future land use designation activity AA15. The table 7.1 under the Chapter 7 of 2020 Comprehensive Plan, Policy 7.8.4.8, rural residential, establish the densities residential uses in agricultural, rural, and activity area nodes. The residential density lots clustered and sizes of proposed new subdivisions would have been governed by the table based on the location of proposed development site and its relationship to its activity node. Any development at the time would have been required to meet the design standards of the LDC or submitted proposals for the development. However, there is no record that the property owner submitted a plan or received an approved development order. Therefore, the applicant did not lose development rights. Prior to the adoption of the Midwest Sector Plan, the parcel was zoned Village Rural Residential VR2. The rural residential zoning districts were characterized by rural land development patterns as stated in the zoning district VR2 to the prior LDC. The VR2 densities reflected the need for more affordable lot sizes for single-family and mobile homes developed, allowing 1 dwelling unit per 3/4 of an acre. Based on the availability data, the residential density of the approval were in fact increased by the adoption of the sector plan and assignment of the conservation neighborhood land uses under the DSEP, which provides the maximum allowance of 3 dwelling units per acre. If approved, any future land use development associated with the parcels will be evaluated during the site plan review process. The review will utilize the current zoning regulations, addressing and minimizing any potential impacts that the proposed development could have on the characteristics of the existing low to medium density residential development listed under the sector plan land uses. And that includes staff's findings.
Okay, thank you. Board members, questions? Mr. Fisher? Okay. Hearing none, we will go into public comment portion of the hearing. Our first speaker is Ms. Jacqueline Rogers. Good morning, Ms. Rogers. If you'll please state your name and address for the record.
Good morning. My name is Jacqueline Rogers. I live on Ridgeway in this neighborhood. Before I start, I just hope that enough leeway is given to me, which was given to the developer agent, where he did a lot of political lobbying. He does not speak for me. He does not speak for the majority in my neighborhood. So when he talks about property owners in the sector plan, I'm here as the other voice. So I will not take as long as he did. I have notes, but I hope that you'll give me a little leeway. It feels like I'm standing in front of the unplanning board and the pro-development services staff that wants to make another exception, another opt-out to the long-range land use plan, which is the Midwest Sector Plan. We spent $1 million on the sector plan. There's data and analysis, and I've read through boxes that the county gave me. Today, you're going to talk about OLF 8, and we're going to do the same things to those kind of plans. This pretended to be professional and innovative planning, but really it's a bait and switch just to get the higher development approved on ag and rural land. And you're no longer interested in preserving some of the rural character of this area as a conservation neighborhood was designed to do. So it's all about upzoning to whatever the market will bear, just like you've done around the county and with our previously protected ag lands. This amendment in particular is a switch from conservation neighborhood land use to mixed-use suburban. That allows 25 dwelling units per acre. It's a comp plan amendment. Nothing outside of the comp plan should be considered. That includes the zoning. The developer's agent and staff can say that it's going to stay low LDR, low density residential zoning, but nothing requires them after this flu change is passed to stick to that. They can request rezoning after that. You all know that. You've done comp plan changes before. Mixed-use suburban allows 25 dwelling units and up to heavy commercial light industrial. It does not allow the industrial uses, but up to heavy commercial uses. So how can you explain to me, the staff, how can you explain that that is compatible sitting adjacent to conservation neighborhood land use parcels? How does that protect the integrity of the sector plan? Is that not a professional planning consideration that we apply in Escambia County anymore? The water franchise, as stated by Mr. Fisher, is Cottage Hill Water, yet there's no verification that there's capacity there. We're going to check that at development review, which is what they do. Every time you have a comp plan, we'll check it out at development review. The high school that serves the area, Ms. Hightower has already testified that it's at capacity. Do you see that in the staff analysis? No, but it is required for comp plan amendment. Now, the developer agent hired a guy from Tallahassee to say that we should bus kids across town as we do that. You already have development going in the sector plan. It's already in development review. Those houses are coming in, but they don't calculate any of that capacity. The traffic analysis was not done for the worst case scenario. It was done for 25 dwelling units per acre, and so, hey, that's an upgrade. They didn't constrain it to the zoning. But there's an assumption that this will stay residential development, and you can't assume that when you're doing a future land use change. May I continue, Mr. Chairman?
The rules of the planning board have been in effect for quite some time. We allow 3 minutes per speaker unless someone donates time or one of the board members asks questions of you. So those rules will stand.
In the past, you have allowed more time, and I am the only other speaker here on this subject.
No, there's more speakers, so.
If I could ask allow Ms. Rogers to continue with her discussion on the data and analysis.
Okay, thank you, sir.
And I will be brief. Anyone who thinks that Neal Road, I live on that road, you saw pictures of that road, that can take 6,745 trips when you didn't do commercial analysis, which this flue will allow. If you look on page 51, Mr. Fisher talked about not leaving a remnant, which is true, but it definitely is fragmenting the wildlife habitat. He said the stormwater systems should be developed as regional systems and encompass multiple areas of development. Where is the documentation that there is a stormwater system there? Residents that are west of that property in Knollwood neighborhood are already flooding now. So again, it's deferred to development review instead of being reviewed as a comp plan analysis. The natural environment and the habitat, the wildlife habitat, where's the analysis for that? That's required for this comp plan amendment, but it's not here. There's no documentation of that. The jobs to housing ratio is already now out of whack. It's over 1.20. There's no analysis to the lack of the design and building standards when you remove something from the sector plan. There are multi-use paths required and things like that. We already discussed, the staff said there's no taking, and I agree with that. So, I'll just end this by saying we have great needs in Escambia County. We have 90-minute waits for EMS. We have 12 vacancies in fire. We are not keeping up with the schools, with the public services, with the bridges and the repairs. You cannot continue to unplan and not plan for other things. There was data and analysis for the sector plan. I've combed through it. There is no alternative data analysis that shows this comp plan is needed, except for developer profit. And it adds to Escambia County's sad legacy of upzoning past our ability to support growth just because a developer wanted. I ask you to deny this, and if you have any questions, I'd be happy to answer them. Thank you.
Okay. Mr. Larry Downs, Jr. Morning, sir. If you'll please state your name and address for the record.
Good morning. Larry Downs, Jr., 12156 Havburg Drive, Pensacola, Florida. Haven't seen y'all in a little bit. Missed the last couple, I think. And just want to start out by saying I am so happy to see y'all with the naked faces. Oh, can you believe that it just disappeared like magic? Anyways, that's just part of the fun of it all. This opt-out, you've already done it. You've already done it for others. You have no choice but to continue this. There's no other choice. You got that constitutional problem of equal protection of the laws. You can't give it to one and not the others. You know, I hear one of my fellow citizens say, this sounds more like the unplanning board, you know. I think we should create a board called the Property Rights Board. You know, that's where our prosperity comes from. This ain't about developer profit. This is about people and property rights. And as long as people keep procreating, they're going to need houses, they're going to need jobs, they're going to need business expansions. We know it. Everybody knows it. You can try to plan it all you want. Oh, get the perfect government plan. Ain't going to do nothing but more harm than good, as we can see clearly. Real quick, I'm sad to see Mr. Westmark is not going to come up here anymore. I love his Jimmy Stewart type presentation. You know, I mean, if I remember right, Jimmy Stewart was kind of about freedom, you know, and he laid it out nice and easy. You know, even his movies was about it, him and his personal life. You know, and freedom is important. Property rights is the prosperity to our country. That's what gave us this prosperity. And if we continue to try to make everybody's decisions on what they're going to do with their properties and make them fit this plan, that plan, there's a plan for the plan for the plan. Anyways, hope y'all enjoyed, you know, the little joke about the COVID. It's gone. Y'all can quit worrying. Adios.
Thank you, Mr. Downs. Is there anyone else that has not speak? Yes, ma'am. Ms. Westmark.
The sound system is really wonderful compared to what we've all experienced before, so whoever did it, thank you. Yeah, can you guys hear me okay?
Yes, if you would just state your name and address for the record,
sure.
please.
Elizabeth Westmark, 2025 West Kingsfield Road. The Zalkelis opt-out obviously has my full support for all the reasons Frank described. And I want to take just a few moments to remind you that the Sector Plan DSAP approved in 2011 projected a 5-year growth plan would generate 3,000 new single-family residences and 1 million square feet of commercial operations. That project must have sounded great to the BCC at a time of struggling to recover from the Great Recession. But we now know in hindsight that the consultant's projection was off the mark by roughly 100% to the downside. After 10 years, the sector plan has produced only 2 small subdivisions and, of course, the Dollar General store. I'm not sure we can give the sector plan credit for that. They're kind of ubiquitous in the environment. No development orders in the sector plan are pending that we're aware of, and none are in sight. The 8,612 so-called developable acres determined to be available in the sector plan were greatly overstated. Roughly 3,500 to 4,000 acres of that total were already developed in built-out subdivisions and houses on mostly small tracts before the sector plan was ever approved. Sector plan math made no distinction between developed property and vacant property within its border. If the GIS wetlands mapping showed that the property was dry, it was counted as developable. Aerial photography and data from the DSAP acreage and calculation tables prove this fuzzy math is real. That means all of the DSAP calculation tables for determining developable acreages and jobs to housing ratios are incorrect and unreliable. Most of the remaining actual vacant properties in the sector plan are not cost feasible for development due to unrealistic regulations, or they lack public road frontage or essential utilities. If the sector plan had one owner with all vacant land like the OLF 8 field owned by the county, in which good planning could have been done starting with a blank canvas, it could have been successful, assuming private sector management, funding, and initiative. But with 1,600 plus properties all dragged into the mix like bubble wrap in a packing box, the sector plan never had a chance to meet expectations. The only responsible thing to do now is to rescind it in a smart way that protects vested rights of property owners, and then consider nimble, flexible planning techniques that will help our county grow in a resilient and sustainable manner. I've enjoyed speaking with you from time to time on these opt-outs. I have high regard and great respect for the hard work you all put into this difficult volunteer service on behalf of the citizens of Escambia County. It really has been a pleasure. Thank you.
Thank you, Ms. Westmont. Okay, anyone else who wishes to speak on this matter that hasn't signed up or already spoken? Okay. Board members, questions of staff or of the applicant? If not, chair is ready to entertain a motion.
Move to approve the opt-out.
Thank you. Do we have a second?
Second.
Second. Any further discussion? All those in favor say aye. Aye. Opposed?
Nay.
Okay, one opposition. Mr. Ingwell. Motion passes. I'm sorry.
Mr. Chairman, could the motion be clarified to also include the assignment of the new flu category?
Yes.
Okay.
I have to give a public hearing if I can't see their lips.
Okay, she said to include the adoption of the flu category in your motion as well.
Yeah, tell me how you want that worded.
It would just be something like a motion to approve the opt-out as well as the assignment of the new MUU future land use category.
What she just said.
MUS.
If
MUS.
you'll pull it back down to the description, it may be easier for them to,
Can I just say what she said?
or read that.
Okay. Oh, geez, now I gotta put my glasses on too. Okay, I'm gonna approve the requested flu for the mixed-use suburban MUS. There you go.
And the opt-out.
In the opt-out.
Okay, amended motion, do we have a second?
Second.
Second. Any further discussion? All those in favor say aye. Aye. Opposed?
Still nay.
All right. One opposition, the motion carries. Good luck with it. Thank you. We're going to move directly into our next public hearing.
Chair, John Fisher.
Sorry, yes.
So next on the agenda is the LOSA and the comp plan text amendment. If we can actually have DBZ go ahead and do their presentation, that way the large scale and the text amendment make more sense to you.
Okay.
Yes. And Chairman, could it be possible for to have like a little 5-minute break so we
Sure.
can get established?
Let's come back into session at exactly 10 o'clock, according to this clock. Give everybody a chance to set up.
Thank you.
Do we have anybody on Teams? Can you hear me?
Whatever makes it easy for you. I mean, we can pull it up on there.
Can somebody unmute on Teams and talk to me?
Hi, good morning.
All that's all you gotta do is ask. Yes. Wow. It definitely makes it easier than causing go through the crowd.
Okay, talk to me again.
Hi, good morning.
Okay, you can hear her.
Yep. We got
All right, on Teams, can you hear me?
That's on, the rent is on?
Yes.
Okay,
Red is
great.
on.
Thank you. I think John's doing it.
Oh, sure.
But I think John's logging on.
I got an update.
Well, whichever one of you gets to it first.
Okay. And eventually I can, yeah, I can.
I don't have the software, so I
Okay.
just go on.
Software, you mean Microsoft Teams? Only is on Teams. But don't, how have you connected in the past?
We're gonna go ahead and get on John's computer, he's gonna connect to Teams, and then he'll display.
Can I just do this?
For anyone who may be watching us online, we're just getting some technical issues worked out here, so we'll be coming back into session in just a few moments.
Thank you.
We're about to. Yeah.
Can we ask either Giorgio or Mary Chell or Philip to let us know once they see the presentation?
Yeah, I can let you know, Marina.
Thank you. There we go. Perfect. Yes.
Yeah, we can see it.
Perfect. We ready? Great.
All right. I hereby call us back to order for the June 1st regular planning board meeting. It's good to have you all here in person. We have the group. I'll let you do your introductions with each of your folks, but good to see you in person. And with that, we'll open it up. Marina, go ahead.
Thank you. Thank you. I'm delighted to be here. My name is Marina Corey. I'm a partner with DPZ, and I'm joined by Mike from DPZ, Travis, who just stepped out to kindly get some water, from Impact Campaigns, and I'm joined remotely by Mary Chell of Nelson Nygaard, Giorgio of GIT Consulting, and Philip of Urban 3. It was interesting to note the previous applicant's attorney speak and talk about not wanting to stifle development or not impose unnecessary regulations. And he asked for the ability to opt out. That's what we were trying to prevent with OLF 8. We want to create fairness, predictability, and consistency with higher standards of development written to encourage a more sensitive and compact development. And if we want to see different development, it's our belief we must change the rules, and this is what I'm presenting here today. Next. Let me go to here next. If you recall, I presented the framework for the zoning implementation phase back in April. We proposed an adjustable regulating plan or zoning map in which certain uses would essentially sunset over time. So I won't spend too much time on this one because I'm going to go into the next slide, please. We're not seeking an upzoning, of course. The land was zoned for public review, and so there are two options that we're recommending be adopted on this plan. That for the FLU, we're saying it should be most of it should become MUU, and a portion of it for C. And both, of course, require a large-scale amendment plan. And we're proposing a FLU of the MUU as it provides the greatest flexibility in uses. It permits commercial, retail, light industrial, and recreational uses, amongst others. The other option, C, with the zoning designation of commercial, is reserved exclusively for those areas where we think commercial development will be the predominant use, or where we've heard the Board of Commissioners request it, where residential is secondary to commercial development. Because such limitations typically require a substantial or costly process to change, we're trying to restrict where the C is imposed. We do understand and recognize the need to prioritize commercial development, and we've done that through the regulating plan, or the multiple regulating plans we're showing you. We are asking for a higher density and a higher FAR in certain areas, and we'll speak to that shortly in the FLU of the MUU. Okay, next. This is the adjusted hybrid master plan. It's slightly different than what you had seen. There's much more land devoted potentially to commercial development. This is the sort of the starting off point. And we've written an ordinance that promotes consistency with the desired physical character of place, promotes environmentally responsible design, and facilitates, we hope, the approvals process for potential tenants or users of the space to avoid what we just saw this morning. So, next, there is a regulating plan which looks at, or actually locks in, mandatory streets. Not, obviously the plan had so many more streets than you see here, but there's a few minimum that we have to have, and this is what this plan will attempt to do that. We're also, through the master plan, putting in some discretionary streets where potential property owners will have the ability to relocate those as they see fit within a certain parameter. And the regulating plan will also assign zoning and designate areas for open space to really create a predictable framework and make it much easier for development to happen. Next. So here's the zoning assigned for 5 years. So what we're doing in order to try have a win-win, win for the county and win for the citizens, and win for property owners, is to have different regulating plans that sunset at a certain time. So if the commercial development can come here as hoped for and predicted and aspired for by the commissioners, then as you can see, there's a lot of land that is zoned for either commerce or light industrial. The Z3 and the Z4 is commerce or industrial. If those uses don't come over the next 5, 10, 15 years, that land would open itself up to a greater variety of uses, which we'll show you in a sec. Along 9 Mile Road, we've zoned it Z3, which is commerce. And, you know, the names can change. We've been told the neighborhood conjures up feelings of residential for a lot of people, may make people nervous. So we're not tied to the nomenclature. We've just put it out there for now. But essentially, Z3 is commerce along 9 Mile Road, which would really preclude residential. And along 9 Mile Road, probably you don't want residential. Z1, what surrounds the commerce, is essentially the only place we're asking for 60 units per acre, which is essentially 5-story buildings. And it may end up being less. But it has a higher FAR, and it's where you have the highest intensity of uses with mixed-use buildings. It could be all commerce, all mixed use, maybe some multifamily, but we're anticipating retail along there. What surrounds it, Z2, is the same uses, but with a lower intensity. It's capped at 3 stories. So essentially, everything is capped at 3 stories, except where you see the Z1, which would go up to 5 stories. A Z4 is the light industrial for the bigger commerce-type buildings, and they are buffered from the residential with Z3, or the commerce types, and we'll speak to what uses they allow in a sec. And CZ, of course, is the civic zone, which permits institutional uses as well as parks. So we anticipate that if the school comes in, it would go into that area. Next. Now the uses are calibrated by zone, and we're using the categories that you're most familiar with. We've consolidated some here. The big difference between the uses permitted in Z3 versus Z4 are the fact that we're trying to restrict retail uses in Z4, which is where the industrial really wants to go, so that you don't have retail any which way. And there's more light industrial buildings in Z4. And I actually have a list of, if you are curious to know, I have a list of exactly what are the uses that are precluded in one versus the other, but we can speak about that later. Next. That's just the full use. We are tying to the existing use categories you have now. We've imposed a few more conditional uses, and those are noted here. Otherwise, the conditional uses that apply in the land development code right now would apply here. Next. So then in 2027, and it may be, that the years may change based on what the commissioners want, the old regulating plan sunsets and a new one comes into effect. And what you see here is that there's a Z4 change to Z2 and Z3 in the southeast quadrant, where it would begin to allow for a greater variety of commerce types, or actually would remove the very heavy sort of light industrial uses that may come in here. And we've talked about applicants who may have a letter of intent already being given. So say someone like Scott Luth has someone who wants to come in and build here, but the regulating plan is sunsetting. If they have a letter of intent or a development permit, of course, they would be approved under the old plan. And there may be even a need to extend it for 12 months if there really is a serious candidate who's coming forth who can build here. Next. And then in 2032, Regulating Plan 2 expires, and this one comes into effect. And if it's not developed or if a tenant is not secured, then Z3 and Z4 are assigned in the northwest quadrant, which essentially allows for a greater variety of residential uses. It permits for all types of residential except single-family detached, which you already have a slew of in this area. So we're talking about detached, we're talking about duplexes, we're talking about triplexes, we're talking about some townhouses, and small walk-ups, 4 units to a building, 6 units to a building, that sort of stuff. So very small multifamily. Next. And in 2037, the Regulating Plan 3 would expire, and this final one would come into effect in perpetuity or however long it needs. And as you can see, the Z5 and Z6 on the northeast, or the top northwest quadrant rather, along Frank Reeder Road would change to allow for some single-family housing if they so choose. Next. So here's the proposed table of contents for the new code. And I can speak in detail or in as little detail as big detail as needed to each of those. And a lot of the standards or the way they're organized are in the appendix. But I just wanted to give you an overview of how it's organized. There's essentially 10 articles or chapters. We're going to plug it right into the way your numbering system works and all of that. But essentially, the first one is general provisions, followed by subdivision standards. So when developers come and acquire land, whether it's for commerce or for residential subdivision, there are rules as to how to lay out the streets, how to lay out blocks, what street typologies to pick from, because ideally there are pre-approved street sections that are aligned with the street standards here. We then have site and building standards, as well as building form standards. So site and building is what's applicable to everything. So how do you measure height? We want to measure height slightly differently to allow for greater variety of heights. We have building form standards, which are what are the zoning standards or the development controls for each of the different categories. Obviously the use standards, and then parking, signage. And then we have landscape and architectural standards and guidelines. So you'll see there's some shoulds and some shalls, and we'll talk a little bit later about that as well. Next. Okay, so the intent. At the beginning, we always have an intent of what this code is intended to encourage. It's intended to activate the master plan. It's what we heard the community say we wanted. It's what we heard the Board of Commissioners say that they wanted. That's why the first three have to do with, bringing jobs to the area, promoting large-scale as well as small-scale development, really trying to make it different to what is currently in the Beulah area. And it's what every project should be measured against. It's a reminder of the multifaceted goals of the project, but it's also something that the planners can be, when they see projects, they should always be evaluating it against this intent to say, is this project meeting these goals? Because there's always going to be applicants who come forward wanting to opt out or modification or variance or whatever. And so we found that it's useful to have this intent that's short, straightforward, it's only one page, and it really reminds people of why this is being done. We're reviewing this with staff right now. They may have some additional suggestions, of course. The other thing this does, the general provisions, is it makes a distinction between shall and should. So shall is mandatory, should is encouraged. And it's very important in how the language is written to try to be as precise as possible, of course, so that it's easy for you all, as you evaluate projects, to review projects and to really understand. Sometimes guidelines are written in such, well-intentioned guidelines are written in a way that's very fluffy and very all-encompassing. And it's hard to interpret. It's subject to each interpreter, so we're trying to be as specific as we can. It also talks about how the regulating plan is activated through the code. And I remember when I was last presenting to you remotely, one of you was uncomfortable with the fact that why would it be applied only here and why wouldn't it be applied elsewhere? I was uncomfortable with the fact that we'd be writing special rules for a site, and so we think that if you're happy with this, there should be language in it that allows a developer to take advantage of whatever zones are written here and maybe applied in other areas of the county. I know that's that's just something that should be considered down the line. It's not what we do, but it doesn't hurt to have that language in there. And it may be in your LDC already. Okay, next. So then each page comes each zoning regulations is sort of a one-pager. It shows the typical standards that you're used to seeing: lot coverage, setbacks, lot width, height, and that sort of stuff. And it's on a sort of easy to read one-pager. We're going to pair it with uses, so one property owner can really see what are the uses I'm allowed to do and what are the form standards I'm required to provide. And of course, the big difference between this and the commercial buildings you're used to seeing is that we're requiring buildings be up against the street, we're requiring that parking be hidden, and we're requiring a certain pedestrian-friendly experience along the sidewalk, which means having a certain amount of entries, making sure that the glazing is adequate, and making sure that the materials are decent, which is something that, for example, Commissioner Burgos has been interested in. And we do allow for variations of setback, whether it's commercial or residential. So that's the Z1 in the core, and you can see the form it's intended to replicate. So this is not intended to recommend any type of architecture, but it's essentially 4- and 5-story buildings, maybe some 3 as well. Next, this is the medium intensity area, which is basically buffers the higher intensity from the commerce zones, and it'll be restricted to 3 stories. It has a depth of about, what is it, Mike, 180 or 120? 120, okay. And it's which is sufficient for a small multifamily building, goes up to 40 dwelling units per acre, and of course, as I mentioned, provides that transition. Next. Then we have the Z3, which is the commerce, which buffers the Z4, which is the industrial. We're showing them at 3 stories because they can go to 3. Some will be 1, some will be 2, some will be 3. But again, here also we're saying that, you know, it's not going to be setting the building very far back and putting the parking in the front. We want this to be of a different character, so we would require that the buildings be up front and that the parking be in the back. Next, and you see the light industrial. This is allowing for larger buildings, essentially. The uses it specifically permits and no other zones include are industrial parks, warehouses, construction trades, and storage buildings. Next, the Z5, the neighborhood general, that's where that's the small area that will encourage as I mentioned before, the different types of residential, townhouses, duplexes, that sort of stuff. Smaller residential character buildings. They have greater setbacks, of course, especially from the street frontages to provide for that a certain degree of privacy as well. And this goes up to 34 dwelling units an acre. And why 34 is because we know that a 3-story walk-up, which has basically 2 units per floor, can go to 36 units an acre on a standard 72 by 100-foot lot. So we have found that a lot of times the density that you permit, and by the way, that's a problem with the DSAP, that it encourages certain forms, but the density just doesn't allow you to get there. So we really want to make sure that we align building types with the density to encourage the kind of buildings that you want to see here. And next, and then of course a small area in the neighborhood edge is the least dense and essentially only permits single-family lots. But it really requires alleys so that the parking can also be accessed from the back. It's not the front-loaded single-family that you see here because there's an overabundance of them anyways. Okay, and that terminates my presentation. I have a lot more slides in the back, but I want to turn it over temporarily to Mary Chell to walk you through the transportation aspects of this, and then to Giorgio, and then to Philip, and then we'll take it back. So, Mary Chell, it's all yours.
Thanks, Marina. Can you all hear me?
Yes.
Yes.
Perfect. So we're going to present just a few slides to show the traffic analysis that we did for this plan, and the table you see on the screen are is the program with the jobs assumptions that we did per land use. Next slide, Marina. The results showed that the master plan as designed would generate 44,000 new daily trips. And this is the result of using a model that accounts for the densities, the land use program, as well as how the walk, bike, and transit networks would be designed. And the results show that out of these 44,000 new daily trips, 8% would be internal, 3% would be external trips that would be done either walking, biking, or taking transit, assuming that there would be some transit serving the site. And then 89% would be external vehicle trips. If we continue looking at the results, we see that 75% of these trips are home-related trips, so either trips from home to work or from home to other, so with other purposes, to other places. And then 25% of these trips are homework trips. If we look at the trips during the peak hours, the AM and PM peak hours, we see that 8.5% of the external vehicle trips are during AM peak hours and 11.5% during PM peak hours.
Mary Chell, I'm going to interrupt you for 1 sec to just give a frame of reference to the planning board members, which is, if you recall, when we last came in front of you, we showed 4 very different plans, and they, some that had much more commerce and some that had much less commerce, and we were tasked with being as aggressive as we could in terms of the potential jobs that could come on the site. So we are assuming, as she showed in her first slide, 5,000 jobs. So the reason you see the daily trips, that daily trip is calibrated on the adjusted hybrid plan I showed you, which is predominantly commercial with a small residential component. Thank you.
Thanks, Marina. Yeah, so here on the left, the chart you see on the left are the the external vehicle trips that would go in and out of the site during the peak hours. So you see roughly 2,500 AM total trips going in, and much less trips going out during the AM period, and during the PM it's vice versa. But there's a higher number of trips going out, because this is during the PM. It's not only the work-related trips, but also trips that are done by other purposes. And to the right, you see the trip generation during the peak hours, and they're split by the purpose. So that would be HVW, that would be the home to work trips. The second column would be the home to other places, so like going shopping from home, and then the non-home based trips, which could be, let's say, lunch from work. Next slide, Marina, please. And then what we did was a traffic analysis, a standard traffic analysis using Synchro software. What we did was looking at two future scenarios. The first one was looking at the growth of the area without including the trips that will be generated from the master plan, and then a scenario with this future general growth plus the trips that will be generated by the plan. And you will see in the map, you see here the intersections that we looked at this analysis. And we use the same methodology that we presented in the existing conditions analysis, which is we looked at the delay, the average delay that each vehicle would have during the AM peak and PM peak periods. Next slide, Marina, please. So here, this is the summary of the results for this future scenario with the regional growth plus the trip generated by the plan. And here, so that's A would be good and F would be bad. And what you see here, so we have the column with the results for the AM peak and the column with the results for the PM peak. And what we see is that there's only one intersection really working, or where vehicles would have a delay that would not be acceptable, and that would be in one of the intersections, one of the entry exits of the site to Frank Reeder Road. And the reason why it's F is because there's 3 entry exits on Frank Reeder Road and 3 on 9 Mile Road. The way we modeled that was that 2 of them were signalized, and there's a third one in each on each road that it's not signalized, and that's what causes this high delay. But what this tells us is that we should signalize the 3 of them. And during the PM peak, we see a bit more delay in Beulah Road and Frank Reeder intersection, which is E. As well as the Beulah Road with Beltway intersection, and the new interchange on the I-10 and Beulah Road on the westbound ramp. Next slide, Marina. Here you see the results that we put on the map. During the AM peak, all the intersections work well, so the delay is acceptable, except from one of the entry exits on Frank Reeder Road, and that's because of the trips that are trying to exit from the master plan, and they encounter those vehicles that are going eastbound on Frank Reeder that are trying to get in. So there's this conflict. And on the PM peak, there's more traffic in the PM, as we saw on this chart. So there's more delay in this same intersection as well as those on Beulah Road. Here, to model that, I also wanted to highlight that we have made some assumptions on the road configurations at the intersection. So we have added some left turn or right turn pockets where there was the highest number of vehicle trips anticipated. But what we recommend is that because this is a master plan, so we did the traffic analysis, but that a more detailed traffic analysis is done as the plan develops. Next slide. And then here, this is the thoroughfare plan, where there's 14 different streets designed, but they are grouped in 5 different street cross sections, which they vary among themselves based on the different elements of the street. And next slide, Marina. Oh, So, well, in the report, you will see the different cross sections for each of these group types, and you'll see how for example, the width of the travel lanes vary, the system of bike infrastructure varies, as well as the width of the sidewalk varies. Thanks.
Yes, and thank you, Michael. This is Giorgio Taciev with GIT Consulting. This shows a summary of the stormwater management on site. The stormwater management system is integrated within the urban plan, and it consists approximately of dry or hybrid ponds of about 31.9 acres. The lakes, which are represented with blue, are approximately 23.9 acres. This was designed with the purpose to take the runoff from the impervious areas that will be incorporated in this plan, approximately in a fully built condition, approximately 96 acres of building and roads. And the objective of the the stormwater management system was to preserve the natural hydrology. The yellow arrows are post-development hydrology, which also follows very closely the pre-development hydrology based on topography and soils. The blue areas, which are the lakes, are distributed across the site and are interconnected with conveyances such as channels or pipes in order to provide attenuation of a 100-year storm event with duration of 24 hours. The entire system is designed to use to the maximum the green infrastructure in order to allow infiltration to reduce the runoff, and infiltration in the ground provides water quality treatment as well. There is going to be a 24 hours retention in these lakes, which will ensure that there is no sedimentation. And after that, the water will be slowly drained to the southwest and to the east sides of the site, and will allow replenishment of of water to the wetlands. The light green areas are wetlands. In addition to these larger components of the stormwater system, there will be multiple distributed smaller components with green infrastructure, which are going to represent also best management technologies such as rain gardens, other swales, which will be retaining water and treating on site in order to reduce the overall stormwater runoff. And the entire system is designed to attenuate the stormwater runoff from impervious systems. Next slide, Marina. Thank you. The green engineering concepts provide green corridors between different blocks to allow time for stormwater runoff to flow and to infiltrate the ground while at reduced velocities, which also provides water treatment. There is multiple components for water quality treatment integrated within on each block, neighborhood, or building scale. And the entire development will ensure that even the parcel scales, there will be green infrastructure components on much smaller scale to reduce the local runoff from the building. The entire development will ensure that there is various other components involved, like such as green roofs or blue roofs to retain water on site. It is recommended most of the roads which do not have significant amount of loads, transportation load, to be considered as semi-pervious. And the entire purpose of this to allow infiltration in the ground and to reduce the stormwater runoff. And next slide. And this is the green infrastructure component. So back to you, Marina.
Philip, are you there?
I think so. Can you guys hear me now?
Yes.
Okay, very good. So our role was to continue the same evaluation that Urban 3 does of the relative productivity in private value on a parcel, which of course turns into your taxes and your ability to provide public services. So this is the way we take the hybrid plan as it stands and then convert it into the likely value of those buildings. And so you see those bars standing up from a couple of different angles, right? Those are not heights. I want to be very clear. That's the expected return relative per acre value, and so taxes from each of those potential development types within the plan. Let's go to the next slide. And so we compared those side by side with the four existing plans from the charrette. So the new hybrid you see on the far right, with a little potential variation there from the residential component with the way your taxes are structured. Some of those residents won't really pay taxes on their full value. So there's a little green bar at the top that kind of fluctuates. And we tried to contextualize that with probably the rough annual road costs that you would see from each of these development patterns. Of course, there are a lot of other costs than roads, but those are the ones we could kind of compare to contextualize the potential budget production for you against the some of the potential costs. So this gives you some context from the earlier charrette process, how the hybrid plan stacks up. Let's go to the next slide. And then we tested out, because of the discussion about potential sunsetting, we tested out what happens if we go down each of those paths. So the larger image on the right or the bar on the far left are the values that we expect to see in total property value as the plan stands, or the second bar in the smaller image in the top right of the slide. What happens if instead, what happens if we take that first sunset, that first change in zoning pathway, and you see a little bit different mixture of uses in that regard. And so you see a little bit different value. You see it go up a little. The second image on the far right, or the third bar on the left, is what happens if we go down the path of that second potential sunset and change in zoning over to include even more of the kind of mixed and residential, a little less of the commercial. You see a little more value per acre coming in there. And then the last bar, or the bottom right image, is that last potential sunset, and how we think that would turn out in value productivity for the county at its end state. We had to advance all of these to when they're someday fully built, so that we could have an even comparison between them. But those look like the pathways to us based on the buildings that could occur. I couldn't tell if that was next. Sorry.
I think that's it. That concludes our presentation. We're happy to speak to you about, there's a lot more in the appendix, of course, and we're happy to answer any questions you may have, or ask any of the other consultants to provide additional details on their parts of the presentation.
Marina, I appreciate a lot of hard work went into this, and looks very good to me. I did have just a couple questions, and I don't want to belabor it, but just real quick questions. And I understand this is a master plan for the area. There probably will be opponents to some of this that may come and say this is creating an isolated district or some kind of spot zoning. What would be your response to those kind of things, those concerns?
So my response is every city, every municipality in which we work has spot zoning assigned through PUDs or PDs or whatever you want to call them. It's recognizing, and the more and more cities are identifying what they may call strategic investment areas or priority areas that require a greater level of scrutiny through their regulations, because it's not getting them, their typical zoning isn't getting them what they need. And so it's not unusual. It's not unusual. Our challenge is really trying to balance out the regulation such that it doesn't put an undue burden on developers. It's going to be more than what they're typically used to, but also assures them they're all going to be treated the same way. Because as you know, not to belabor the point of the previous application, but once one developer knows that he can opt out or he's going to be held to a different standard, that's when you see people coming to you constantly. And so our hope is with this plan that it makes it easier for them, that the permitting is facilitated. The whole reason to activate the master plan as a guide, because it's not a regulatory tool, is to say, if you follow this plan, it's going to, and you follow these rules, the permitting should be much more straightforward. Now, as I said, they could always opt out, not opt out, seek variances or rezonings and follow the regular process. But it's not unusual to see this at all.
Well, I'm glad that you moved into the subdivision standards. I understand that there may be different design standards and different requirements here, but do we foresee on the technical side of things that it would change the actual construction procedures for, let's say you're building a roadway in one part of the county and then you come to this? Do we see a change in those actual technical standards, different road bases, different types of materials, things like that?
So we're not getting into any construction standards, so road bases are going to be the same. We're here for 4 days now to review this code in detail with staff to really make sure that they've had their own, all their different disciplines look at this code so that we can actually make sure it's completely aligned. So for example, street sections, we're saying, for example, there are some areas where a 10-foot travel lane is appropriate, not an 11-foot travel lane, but insofar as it's allowed in your own standards, and this is where it's applied. It's that kind of thing rather than creating a whole new set of standards. And as I said, we're not touching construction methodologies.
And so it would be more, for lack of a better word, aesthetic uses of the standards to make sure we have what we're trying to accomplish here.
Correct. It's much more on the architecture of the building or the urban design standards,
Okay.
building, that sort of stuff.
Okay. And just my last question, and then we'll allow some board members to ask. I was impressed with the transition areas between the stormwater. I wonder how the stormwater lakes will look. A lot of us have a negative connotation of what retention ponds look like. We see this fenced-in area with weeds growing all over the place, and I know that's not what we're shooting for here. So how will we use the lakes to be more of an amenity than just a retention pond?
Yeah, so I'm gonna say something, and then I'm gonna open it up to Giorgio if he wants to add to my comments. But we have the same concerns, and we've incorporated into this a couple of things. One is that if the stormwater lakes are sloped in such a way that they don't require fencing, then they can count as part of the open space requirements, and they are an amenity for the community with jogging paths around it and that sort of stuff. So that has been written into the code, and we're continuing to get standards to incorporate into here. And I think, Giorgio, correct me if I'm wrong, but your calculations for the ponds are such that they are all considered, that none of them are to be fenced in. They would be smaller if they were to be fenced in, correct?
Yeah, that's correct. Yeah. None of these will fence. Actually, they will be designed to be used some for use recreation. None of them will be a single use lake or hybrid pond.
Thank you, but it's not only in the pond, it's in the whole water conveyance system, having a series of rain gardens and having, pervious pavers where it's possible. Parking, for example, would be one obvious place. They can all help with the slower infiltration and channeling of the water.
Okay, so we do foresee that these would be lakes and not dry retention ponds when there's not a lot of water coming into the area, that they would remain as a lake or more of an amenity for the area and just handle additional water through the use of flow techniques. I don't want to get into all the construction side of it, but
that is the intention.
okay, all right, very good. All right, board members?
I had a quick
yes,
question.
Yes, sir, Mr. Rushing.
Regarding the traffic, it seemed like the morning, with people going to work and people going to school would be actually higher than going home. But it was significantly higher going home in the PM rather than the AM. I just didn't, I guess I didn't understand how that was, because, school comes in and you comes home at 3 o'clock or whatever. But they all leave at the same time, usually between that 8 and 7:30 and 8 o'clock.
I have an idea, but I think I'm going to let Mary Chell answer it because she's going to be more precise than me.
Yeah, well, first I wanted to say that we accounted for the new school in the site, so that's in the numbers. But in the afternoon, there's normally when there's retail, in the mix, this is when the trips, the additional trips, this is the reason why there's more trips in the PM, because people might go to shop in the site.
And also take people to, take their kids to ballet or take their kids to judo and that sort of stuff.
So what normally happens is in the PM, the purpose of trips, it's more diverse and there's more activity happening.
Additional questions?
I was going to ask the county if you've had any interest from the private sector, anybody eager for any type of development that, obviously we're here for the plan. It's great. Like I've always said, the trick though is incentivizing, I guess, the public sector to come and join in, because otherwise they're pretty pictures.
No, not at this time. There's been no real consensus of anything.
Hold on just a minute, Mr. Downs. Any other questions from the board?
Mr. Chair, can we get an update again on when the Beulah Road ramp would be going? It's projected.
So it's still very broad because we never know what's going to happen.
Yeah.
There's, what I've been told through the TPO as a TCC member is if we got the funding today, it will take 5 years till it's finished.
Okay. And then
So the expected last was anywhere between 2028 and 2030.
And Ms. Hightower, that's why, in fact, the regulating plans are scheduled the way they are to account for there may be there are going to be some tenants for whom highway access is the most important consideration, and there's leeway for them. Right. There's other potential employers for whom quality of life will be a more important goal for their employees. And so we're trying to balance the two out. But it's really the regulating plans are key to those anticipated dates of the Beulah interchange.
Mr. Chair, I have one more question. On the general provisions section, are these things that have been discussed with the Board of County Commissioners? I love the general provisions, but you just sat through one of our opt-out issues. And, because I truly believe that, if we're going to plan, we need to plan. And because this land didn't have any other zoning, we're creating it here. So there shouldn't be, I say that, no, I'm not going to say that.
I'll say it for you. It's easier than the big DSAP you have, because it's obviously first, this plan has benefited from a master plan. Right, so arrived at a little bit with community consensus as well, and with the Board of Commissioners' general support. Some more than others, of course. I'm sure they've seen this at the same time you've seen this. They may have additional comments on it. I don't know if they'll get into it with the level of specificity that you all get into it, but we don't know what they think about it. We're presenting to them on Thursday.
Board members, anything else? Okay, this is a public hearing. Mr. Downs has requested to speak, so we're going to allow him to have a few minutes here to speak. Mr. Downs?
I won't need more than 10 minutes. No, I'm kidding you. Real quick, 10 seconds, there we go. I think we need less rules and regulations. And we need more, I'm trying to figure out how to say that. How about flexible guidelines? That's what we need more of. And we do need more development. I would prefer the government not to do it, but here we are. So I'm in favor for more development. We have to have it. We have more and more people. We might have 500 people moving here every week, maybe every month. Maybe 1,000. And we need people to have places to live, places to work. I agree with some of what she said. I just wish the government wasn't involved with it. All right. Adios.
Thank you, Mr. Downs. Okay.
Can I respond to him?
I'd like to comment to that.
Yes, let's allow the board member, and then we'll come back to you,
I'm fine
Marina.
with her speaking first. Good. I was going to say that because I'm one of the ones that has spoken up about this. I personally would like to see as much commerce there as possible. I think the advantage of that is then the county, the government, is not really involved in the development itself. It bothers me a lot that a number of the people that come in here and beat the drum to hold back on growth, you witnessed some of it this morning, are the very people advocating to sock some people in here, excuse the expression, like sardines. And it's only 3 or 4 miles down the road. And the only real difference is that county leadership was pushing one and not pushing the other. And I'm not so sure that that doesn't drive some of these people's positions. But I will say this, that I have I have a strong objection to the idea that we're going to do this in this block of land and 3 or 4 or 5 miles down the road where a private landowner who's owned a large piece of property for a very long time is not going to receive the same kind of competitive edge, puts him at a disadvantage, puts him at a risk. And I don't think our government should do that to people. That being said, your plan itself, I have no real objection to, other than that, you know, I was a Florida West board member, and I leaned more towards what some of the original efforts were intended for when they went after OLFA.
You know, there's a city in Canada that has imposed rules that say for every additional rule we put in, I think it's I don't remember which one it is, Mike may remember since he's Canadian, for every new regulation we add, we have to take away 2. So, by the way, we are rewriting Orange County, Florida zoning regulations, which are going from 1,200 pages to slightly under 300. So we believe in simplifying regulations. On the other hand, your county looks the way it does because of your zoning, and there are certain areas that really deserve to be improved upon. So the place I would slightly disagree with you, Mr. Salmons, is the fact that this land is imposing additional standards on development because it is county-owned land, and it is land that the commissioners have decided is worth being more judicious about as it develops. So it's not less standards, it's actually more standards. Yeah, that's what I'll say.
I'm going real quick, but I would like to say our county's beautiful, just the way it is.
Thank you, Larry.
Thank you. I got to get to work.
Oh, and so Travis is reminding me that Scott Luth, who is also advocating for commerce on this site, has been looking at this, and he has provided comment, and we are working with him. It's also worth noting that, you know, in the places we work around the country, we have been hard-pressed to find one municipality that is looking to devote over 300, let alone 500 acres to a single use, if it's not going to become an industrial park. And every place deserves an industrial park. Our belief is that this is not the site for it, but that there is significant amount of commerce that can come on the site. And everywhere we go in cities that have significant commerce, all they want to know is how do we bring housing here too, to help our employees. And the good news for this site is that it's large enough to accommodate both. It can accommodate a significant number of jobs, and commerce through these regulating plans is really being incentivized by saying, if you bring the commerce here, those are the first uses that will come in. But if they don't, then let's have a plan B, and that's what we're trying to do.
Let me ask both county staff and our consultants here, and I understand Mr. Salmon's concerns, and to a certain extent I would agree to some of that, but if a private citizen had a parcel that was this large, and would they be able to go through a master plan? Probably not. It would be more of a PUD project, but they would still be able to get consideration for certain things. So there is an avenue for them to be able to go in and establish commercial and residential all in the same district. Is that correct?
Yes. To answer your question, yes, if the zoning does allow for a mixed-use type of zoning category, where basically if they want higher standards, the PUD process. It would be a PUD. Basically, they would have to give something. The county would have to get something in return. But if the zoning does allow for a mixture, we do have plenty of zoning category that does allow for a mixture, and that's what the PUD is, the plan use development, where the county can get something and they offer something. So the answer to your question from a general overview is yes.
I think his concern is that, because of the use of a master plan, that this property may enjoy some consideration that you might not be able to get if you had a private property. I mean, to a certain extent, I think that's true.
Can you give a specific example of one of your concerns? I just want to understand it a little better, because I see it differently, but I may be not seeing what you're seeing. So I just want to give one example, because there are additional rules here that your zoning code, for example, don't have.
Absolutely.
Bear with me. I don't know if I can give you a specific example, other than that just 3 or 4 miles down the road, there is agricultural properties that we are holding them. They can only have one house per 20 acres, kind of a deal. And it's some of that same thing is going on with the sector plan stuff, where we're restricting in quite a significant way the number of units that can be built per acre. And the numbers are so restrictive that the property owner, who may have owned that property for 40 years, or in some cases 70 years, who now needs to sell it for whatever purpose, has to jump through hoops and deal with constant battles, and can't sell their property to someone and get the maximum price out of it. Now, you can make that argument about a lot of areas, but it troubles me a little bit that then the government comes in and says, we're going to take this block and we're going to make sure it's done this way, and we're going to spend some of the dollars to get it done. And I just think it's inherently wrong. Now, that being said, we're faced with the situation that we made a swap for OLF8. We spent a ton of money in Santa Rosa County to get here. And it's clear to me that it's going to be difficult to go with what the original intent with of the property was. It's just going to be politically impossible almost. And so from the standpoint of that, I have no objection to this plan. But from the standpoint of the way we treat the general property owner and the taxpayer in this county, it bothers me a great deal.
If I may, Mr. Samuels, I think this is more or less, your issues are, yes, sir, thank you. Your issues are well noted by the county and by the planning board and by the planning staff, even by the state legislations. The county is looking, the state law is for, not just for this plan, the county is looking at additional oversight, additional overview to yet keep the zoning intact, but to yet streamline so that the local citizens that got land can basically be able to develop their property to the maximum possible based upon the regulations. So again, there's going to be a legislation that's already been approved by the board, by the Tallahassee, and we're just waiting on that to come to law. Well, basically, with for example, a small-scale map amendment is 10 acres. That's the state law. But the state law is changing that now if someone has 50 acres in the rural part of the community, that basically they don't have to go to Tallahassee. That issue can be handled strictly by the board, by the BCC. So the law is changing drastically for the rural community. We just adopted a process for the AR flu category. Tallahassee approved that, the board did. So we're looking at those things. Many of our zoning is still archaic and it's antiquated, but we are definitely looking at ways to make it easier, yet understand the role of zoning and the role of land use and the role of good planning and smart growth. So it's a balance, and the county is looking at trying to make that balance.
Can I just
Let
add?
me just make one thing clear, because I can see where it may have sounded like I was. I'm not finger pointing at anybody.
Absolutely.
I'm finger pointing at the situation that we're in.
Yes, sir, absolutely.
And I don't think that anyone, in fact, everyone on this planning board bears some of the burden because they voted for the people that did what they did to start with. I mean no disrespect to y'all.
Understand, sir. I just like to be clear because I'm glad that you're a new planning board member. And sometimes it's good to get new people that come on the planning board to look at those things. So to keep it fresh for us. So we don't take offense to anything that you stated. Thank you.
Mr. Salmons, I want to say one other thing to you, which because you're asking the right questions. But I think there's a scale issue. So I understand that you worry about a property owner who has land that is zoned ag who may wants to rezone. That is a sort of a comprehensive plan issue. We are coincidentally we're helping Orange County with their comp plan at all as well. And so what we've done there is identified areas that are going to remain rural, identified areas that are going to remain established, meaning they're not going to change that much, areas that are intended for growth, and then areas that are targeted for significant redevelopment. If we were to do this for the Beulah area, the OLF8 site, by virtue of its adjacency to Navy Federal, it's a very large contiguous piece of land in which a lot can happen, it would make sense for it to be considered a targeted area for significant redevelopment because just by virtue of its location and everything else. So your comprehensive plan looks at how you grow and where you want to direct your growth. And that's where someone who has ag land would know whether they can rezone it to 1, to 2, to 5, or to 10, irrespective of the OLF8 zoning.
Can I comment?
Yes, go ahead, Reed.
Also, one of the things that we've got to consider is the cost to the citizens of expansion. As we expand into ag areas and we extend our services, our road services, our fire services, our water services, all those services, you and I pay for those as citizens. The burden is not on the development that says, oh, we're taking the services that are around here and we're going 5 miles out. Oh, the developer doesn't take those burdens on, those extra costs to you and I. We all do as citizens of Escambia County take on those burdens. So as I am a very big property owner's right, but I also understand property owners' rights to an extent of cost to the public. And as we grow in Escambia County, of course, the ag area is the places that we can grow to. But if you're too far out of a core area and you decide that you're going to put 200 homes into this area, that cost is overwhelming to our services and to our community as a whole. Therefore, that's why planning is so important, to keep those in perspective. Everybody wants to be able to sell their property for the maximum use, but is it the right thing to do for the community as a whole because of the extension of our services? So that's my thoughts. We do need density. I mean, density is what makes the government, profitable.
Just for the sake of argument, and I really don't want to continue this because I get the point. I'm 1 out of 4 today, I think, 1 out of 5, but I felt the need to speak up. But I'm going to say one more thing, is I have been paying for infrastructure and utilities in this town, and they've gone up and up and up due to growth as much to inflation. And I know that firsthand because I have worked on the documentation to support it and been to Tallahassee and pitched it.
Thank you, sir. We do have another gentleman who has signed up to speak, Mr. George Levy. Yes, sir. Please come forward. If you'll state your name and address for the record, sir.
Thank you. George Levy, 2512 Sweetheart Lane, Pensacola. I'm over off of Pine Forest Road.
Okay.
I've been involved in this charrettes and the surveys and everything else. Hi, Jay. I didn't know you were on this. Howdy. I have a concern, fundamentally, and I've expressed it multiple times, about the whole charrette process. I think there's something missing in that and I can give a very simple example of the flaw. Okay, who likes ice cream? Does anyone like ice cream? Anyone like ice cream? Anyone else? Horace? Not eating ice cream today? Okay. Simple question. Now, who wants an ice cream parlor? Of all the stuff we're building in the town center and everything else, who wants an ice cream parlor? It'd be nice to have one at the town center. Who wants ice cream parlor at the town center? Huh? Nobody? Okay. Who wants discount free ice cream? Discount. It sounds good, right? Fantastic. Well, that's the end of the charrette. No more questions. That's the end of the charrette. That's the question. So we're going to build an ice cream parlor in OF8. We don't need anything else. When you look at the surveys and the questions, okay, they were not very wide casting. What I considered, I was on that committee with Jay that Burgash put together. When I heard that Space Force was looking for a place to put a headquarters, the mayor put in a pitch to put it down at the NAS. But I said, I was thinking that would be a perfect, if we wanted business and commercial and jobs, put in a bid for the Space Force, that Space Force would be a home run. It'd be a grand slam home run. And in my original surveys, questions, I said, have you gone out to industry? Have you gone to the military base and asked them what they would like to see? And have you gone to the Space Force and said, hey, we got this perfect thing here, okay, high-paying jobs, okay, and it'd be nearly semi-permanent. You look at who's the neighbor up there, Navy Federal, okay, those are office admin, high-paying, well, they're not high-paying jobs, but anyway, it would be an upscale instead of these ice cream shops. So when you start looking at, go back to the charrettes and the questions, there should have been a weighting instead of who wants this, 1, 2, 3. It should have been name the top 10 things you want and rank them that way instead of do you want this or done that. It really was a gap in the charrette process as far as I'm concerned. And everyone wants housing, but it doesn't have to be there. It'd been perfect to have commercial and industrial. And, you know, in other industries we're building, you know, ST Engineering, you got the NAS, you got the aircraft engineers over there in Boeing, whatever, over in Mobile. If people have gone to industry, ask them what they could do to support it, you know, what support they would like to have and have it at OF8. I don't think that was done. I don't think they cast the net wide enough to get all this. Okay?
Thank you, Mr. Levy.
Thank you.
Appreciate it.
I have a quick question for George. George, I didn't see the questionnaire for OF8, but how did it compare to the questionnaire that was put together for the overall Beulah Master Plan? In your opinion, how did it compare?
I don't know, the whole weighting, I don't remember a whole lot of detail. It was really You know, I'm familiar, I've been in engineering since the 70s. There was a process called Kepner-Trago, and you listed things and you weighted them and whatnot. What do you want? You know, what's a priority, what you want? I didn't see anything like this. This was just a popularity contest and whatnot. But I'd have to go back. I do remember, but I didn't see anything. You know, the first casting of the net, really, I mean, the questions were targeted, focused.
Thank you.
Can I clarify?
Thank you, sir.
We didn't ask those questions because I agree with George. You know, asking people if they want an ice cream store doesn't help the process. The reason one of the reasons we hired Weissman and Associates was to do an economic analysis to tell us exactly what can come here. So the survey, there was a survey, and I saw it before, it was provided to us when we came into the project, a survey done by someone that asked people to rank everything they wanted. Like, what do you want here? It's like a wish list. And that's exactly how we do not conduct our charrettes, because a wish list doesn't do much. Our task was not to go recruit tenants. Our task was to design a plan that would appeal to as great a variety of tenants as possible. So if the Space Command group would want to come here, there'd be a place for them. If a smaller commercial tenant wanted to come, there'd be a place for them. If a greater tenant would want to come, there'd be a place for them. If an ice cream store wants to come, great. If it's a hairdresser, great. Whatever people find they need. Now we got a sort of a gaps analysis. Peter Bazzelli from Weitzman and Associates was very clear in terms of here's how many housing units can come here. Here's the kind of retail that can come here based on what exists around, where there are gaps, where we know what we've heard people want. Our job was not to say this is where they go. Our job was to say let's design a plan that will make it as attractive as possible for them to come here. And I just wanted to be clear about that. So people use the word charrette left and right. We're very rigorous in the way we run our charrettes. It's not everybody give us your wish list, I'm going to write it on a piece of paper, and there we got public input. That's not how we do it. Thank you.
Okay. Thank you, board members. Any additional questions for the consultants or for the staff? Okay. On public hearing 5.2, do we have a motion to move forward providing a recommendation to the Board of County Commissioners?
I thought it was a discussion item today.
Yeah. All right, so let me, John Fisher.
I'm sorry.
Yeah,
I'm
so,
looking at
yeah, let me give if I can share my screen here, let me switch it around to another slide here, give it a little timetable. How do I go back?
This is for the future land use.
Yeah, let me, before we move off the discussion, let me clarify where we're leaving from here and what we're moving, how we're moving forward with the LF8, just for everyone. Yeah, this discussion agenda item 6 is what we've been on, the LF8. So let me pull up. Okay, so right now I'm gonna basically just share our tentative timeline with the LF8 master plan. So today you can see June 1st. Basically, they're giving us a presentation update. DBZ did today. Where we're at, we're supposed to go to the planning or the BCC with recommendation on June 3rd. We have been given more time because staff has not had a chance to look at the code part of this. We are seeing that the code has got to take several weeks, months to finish up. We've got a lot of the code, but we still have to implement the stormwater. We still need transportation. Has not had a chance to review, or stormwater engineers have not had a chance to review in-house. DBZ has done their part by giving us the code, but we still have a lot of questions, concerns where Escambia County staff is reviewing the code. So we're hoping, or looking at what the BCC will say on June 3rd, whether they want to continue to move forward and wait for us to bring back the master plan sometime in October, because what we're going to, after we get done with this discussion here, we have the future land use 2021 map amendment, and we have the CPA 2101 text amendment. Those are processes that have to go to DEO, which we know take 90 to 120 days. That will give staff enough time to go over the design code, look at it as entirely, make sure we get everything right, bring it back to you guys in sometime August, September, maybe October, for a recommendation to the BCC so we can move forward. The master plan cannot be adopted without the future land use and the text amendment being adopted first, coming back from DEO. So June 3rd, we're hoping for the transmittal to go to June 3rd BCC meeting, that they will approve that as a transmittal. We just wanted to give a little background for you guys would understand as we go to the future land use and the text amendment on the agenda. That way it made it a little more easier to understand, what we're asking for.
Okay, that's fine.
So John, so now we're going into the public hearing for them to make a recommendation to go to June the 3rd, the future land use and the text amendment, correct?
Yeah, we have to do the staff analysis and stuff for the large scale, then the text amendment.
Okay. And just to correct, because when I called the meeting to order, I mentioned that we're going into the public hearing concerning the flu map amendment, LSA 2021-01, but we were really having a preview discussion before we go into the actual presentation from you at that point. Okay.
Correct.
All right, so let's go ahead and go forward with that portion of it then.
Okay. I believe DBZ teams that are online can most likely stop the Teams meeting. They don't have to participate anymore. I will ask DBZ that is here if they want to sit just through the future land use, in case there's any questions about the future land use change. Yeah, that'd be the only reason for Marina and Mike to really stay.
If you want us to stay, we can. Otherwise, I think we don't need to. It's up to you. You tell us.
I think we should go pretty quick on this part because they pretty much know the history. Just in case any questions go, why the density, why the FAR, just that way we can, we have it. It's all part of the present.
So thank
package.
you, Mary Chell, Giorgio, and Philip. You guys can go.
Thank you. Bye.
Bye.
Okay, and I'm going to switch this back over to the other computer, so give me 1 second to unhook mine. All righty, we're all set. Yep.
John, I think since we've had such a, in-depth introduction into it, just a very brief overview of exactly what we're recommending, so.
Okay.
And then the board members can ask questions if they have specific questions.
Okay. So this is the large-scale 2021 outline field 8. This is part of, the proposed for the master plan adoption. So what we are looking at here is to change the future land use from public to a mixed-use urban area of 457 acres and a commercial area of 81.28 acres. The zoning designation for the reference parcel is currently zoned public. As we hopefully adopt the master plan, that will change the overall public zoning to what you saw earlier in the discussion, Z1, Z2, Z3 type of zoning categories when we adopt the master plan. The applicant is aware of the current zoning and the future land use are not compatible. This is how we kind of do some of we've got to do the future land use first before the zoning. However, Escambia County is proposing a new master plan in a new zoning district called Outlaw Finding Master Plan District in Chapter 3. We're actually going to be changing that to Chapter 7. So that's one thing we will be needing to amend. We looked at a plan to create, after a discussion of going through the design code, we decided to call it a brand new chapter because it has its own zoning regulations, stormwater, traffic analysis, keeping it separate from the regular land development code. It's part of the land development code, but we're not going to include all the design standards of the regular. So this would be its own Chapter 7 of the land development code. The new master plan will provide multiple new zoning categories and new enhanced design standards. The applicant has submitted a OF8 master plan in conjunction with the request of the future land use change. The applicant understands that the outlying field, OF8 master plan district approval will be necessary for the future land use compatibility. So the proposed activity for the new master plan, which include, retail, multifamily, over retail, multifamily, standalone, commerce, area, office, and townhomes. You can go ahead and, if you want to bring up the maps for we can show the current and the future land use changes here. Just kind of, I think they kind of got so there's the road area network, wetland map, zoning map. And so this is existing all public. And this is what we're looking to propose. You can see the acreage is there. So we'll be doing 457 acres of mixed-use urban, then 73 acres of commercial. With the 7.81 acres down at the bottom. There's two sections. Depending on how the board feels, we can go through the staff analysis, but after the discussion that we just had with, just want to see if there's any other questions. I think this kind of speaks for itself on this part.
Yes.
Mr. Chair, or maybe this is for Kia, but in the verbiage of what we're changing from and to, do we have to be as specific in what we're changing to MUU and C? And the reason I ask is because in this square block, we have, it's almost a different animal altogether. And they've already given, sunset rules from down the road where things will change and move. Are we kind of painting ourselves into a corner by specifying 81.97? I mean, 88% of it is going towards mixed use, which I get, but.
No, so what we saw earlier, those will be the zoning categories, what we saw earlier. This is the future land use. So, what we're saying is, the northeast corner of the commercial, that's predominantly, that's part will never change. And same with the commercial area. So that zoning area will never change when it sunsets. That is actually will always be a commerce area type. So we don't have to worry about any zoning changes or putting us in a corner or anything like that. And the sole provider of these layers is our GIS for the acreage, so we have actually mapped them out. We hold the shapefile for the future land use, and this will be the sole provider of what acreage we would need.
Okay, staff, the appropriate level of analysis was done for this comprehensive plan according to meeting the Department of Economic Opportunity standards as well as the county standards for it?
Yes, it was. Yes, it was for the future land use category, since we are basically given this parcel, given this parcel a future land use category, the appropriate review, the appropriate in compliance with the state statutes was done. We just got to have it transmitted to Tallahassee. Have the board look at it. Then, if the board so wish, they can say yes, transmit it to Tallahassee, or the board do have the option to send it back. The board, this board just make a recommendation. The BCC will basically have the final authority to either say yes, take it to Tallahassee, or send it back to staff and to the planning board for further review. I do want to state that for the record.
If this board recommends and the Board of County Commissioners transmits to Tallahassee, and then there's a change in the plan or an amendment or anything, we'd have to go through this process again to update all of this?
Yes.
Okay, so are we getting the cart before the horse then?
No, so DBZ will be presenting to the BCC just like they did today.
Okay.
Letting them know where they're at, what the plan is. So if they see any significant changes that they do during that presentation, then we get to this. Obviously, if this isn't going to work, they're not going to transmit it.
Okay, all right. So they're going to have the information before they decide.
Correct.
Okay. All right, board members, I think all of you have been through these future land use map changes. It's up to you if you'd like for John to go through each specific item and read them in, or if you just have specific questions. Okay, hearing none. I think we have on the record that it meets the standards. Horace, your neck is on the line for saying that, so.
It meets the standards as provided by our professional planning association.
Okay, there it is. Good deferral.
The buck stops here, Horace.
Mr. Pyle's comment, which is, we're trying to please multiple opinions.
Absolutely.
And so this is, Commerce doesn't say that it doesn't permit residential, it's just much more restrictive. A more obvious way to have achieved it would have been to say zone everything MUU and then allow for the industrial zoning we did through the zoning and not through the land use could have achieved the same result. But I think this is a bit of a compromise to appease some of the commissioners, which has to happen as well.
Yes.
Understood. Okay. If there's no other board questions, then at this point, I'll accept a motion on 5.2, which is the transmittal recommendation to the Board of County Commissioners on the 2030 Future Land Use Map, LSA 2021. Go ahead, sir.
Regarding LSA 2021-01, I recommend approval of the proposed flue change as written.
All right,
And
thank
I
you, sir.
second that.
Motion and a second. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Now we go into the second portion of this, which is an actual public hearing, 5.3, which is, this is more of the text amendment. Is that correct, John? The second
Correct.
hearing? So it's exactly the same thing. It's just the updated text amendment for the comprehensive plan. Is that correct?
Correct. So I can give a really quick synopsis on it. So in order to match the densities that were in the discussion that we had earlier with the Z1, we need to add language to mixed-use urban where it says 25 dwelling units per acre, which is standard for mixed-use urban, or 60 dwelling units acres if within OF8 master plan. So we're only allowing 60 dwelling units within OF8, nowhere else in the county. And as well, a maximum intensity of adding 4 floor area ratio within OF8 master plan district. And in the commercial future land use category, we're not changing the density. We are actually changing the FAR from 1 to 2.5, only within the OF8 master plan district.
Okay, so those are just those items that are specific to OLF8 master plan. Okay. Board members, any questions on those changes? Hearing none, Chair will entertain a motion.
Move to approve.
Move to approve as presented. Do we have a second?
Second.
Second, any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Okay. So maybe everybody should watch the meeting Thursday night and see what the commissioners have to say, right?
And let's be clear, because it's got to be consented. The Pacific transmittal hearing would not come before the board on Thursday night. It's going to be what time, John? What's tentatively set? July. So I just want to be clear because it was, they pull everything, so, but it will be proceeding according to the requirement deadlines that's set by this staff and by the BCC.
Okay, all right. Very good. Thank you. Appreciate it. Good meeting you in person.
Thank you.
All right, do we have anyone who would wish to speak in public forum? All right, hearing none, we will hereby close public forum. Horace, anything on the director's review that you'd like to go over?
Just briefly, just provide an update. Yes, as you know, there were some opt-out challenges that went before the judge. An administrative challenges that went before. That was on the opt-out case. That was for the Westmarks and for another. Yes, yeah, Clyde and Cynthia Jolly. It was challenged, and the county came back successful in both of those opt-out cases. The same information that was presented today, the same rules that the staff presented today, it was challenged by an individual. The county prevailed in both, and the first one was Mr. Wilson Robertson. After I request the county prevailed in that one, and the county prevailed in Mr. and Mrs. Westmark and Clyde and Cynthia Jolly. So I just want to provide the update.
And just to be clear, Mr. Chairman, we have received a recommended order from the Division of Administrative Hearings. So the recommendation is that the ordinances be found in compliance with state law, but we are still awaiting a final order from either DEO or the Administration Commission, depending on what the final order is. And then also, we have pending an appeal to the more recent opt-outs for Pine Top and Highway 29. That was the First Baptist Church and Cleveland Campbell. But the petitioner in that case has stated an intention to withdraw that appeal if the county prevails in the first set of opt-outs, the Westmark and the Jolly cases.
Okay. All right, thank you for that update. As always, I'd like to find out, is there any cases where the commission changed the recommended order from the planning board that we know of? Okay, all right. Kia, did you have anything else for county attorney's report?
Nope, nothing else.
All right, thank you. Next planning board meeting will be July 6th. It'll be here in this room, July 6th. So the 4th is on a Sunday this year, right? Okay. Okay.
Yeah, July 5th is recognition of the holiday.
That's what I was thinking. Okay. Just please be diligent to make sure that we have a quorum, because I'd hate to get everybody here and then we don't have a problem. So, and while we're at that, did everyone get access to your My Escambia email by updating the passwords and everything? Okay.
I did not. I didn't. I chose not to. I've been replying personally.
Okay, I think, okay. So Rachel, you had sent out instructions on, was it you or Kayla? Kayla did, I'm sorry. Sent out instructions that who to call in the county to get those passwords updated. We cannot apparently do it ourselves. We have to get the IT group to do it. Just keep in mind, and Kia, you can correct me if I'm wrong, but if you receive information to your personal email, then it is subject to being reviewed under the Sunshine Law. So that's why we had set up these email addresses for the county, so that that would be your official way to use communication. So just realize if you do something else, then you're opening yourself up to a review on your private information. So, okay, anything else? All right, we are adjourned. We'll see you. Have a good 4th, everybody.